Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Hello, my couch potatoes. Welcome, welcome, welcome. It is Thursday, February 26th, and we are here for our new favorite thing. Talking shit about Laura Owens.
Yes. And I mean, ChatGPT is a friend of hers, as you saw, and doesn't want me to do anything with her name in it. So she's maybe sued them.
I think so. We tried to do some fun logos. It didn't take.
That's okay.
It didn't take. Well, everyone, thank you so much for being with us today. Please go ahead, hit the like button, subscribe, hit the notification bell, because you do not want to miss us while we are on this wild journey that is Laura Owens. Probably like the worst odyssey ever. But today we're going to be covering, so we finished up Michael Maricini on Tuesday up to 2020. And today we're going to go into two civil lawsuits, one against Uber, Laura versus Uber. And the second one is Laura and her mom, Jan, also Elizabeth, whatever the hell her name is, versus Lone Cactus Construction. So that's what we'll be doing the next 2 days. It won't take very long, and then we'll get right into Greg next week. Now, if you don't know what we're talking about, we have a whole Laura Owens playlist. Please go catch up with that, because there's not a single thing you want to miss. Everything is like binge worthy.
Everything is.
It's just like you can't get enough. Now, I also want to quickly thank everyone for all the love and comments you guys have left. You guys are freaking amazing with your information coming through constantly, and we really, really appreciate that. For sure. And also a shout out to the victims of LauraOwens.com, where we've gotten a bunch of these court documents. So thank you guys for that. But before we get into Uber, we got to talk about some breaking news. And that breaking news is that Laura Owens was offered a plea deal for her felony charges yesterday. We don't know the details of it. And they put a deadline. They put a deadline on it. Sometimes they do that. Sometimes they don't. I don't know if it's state by state has laws on it. I don't know. But I know hers has a deadline for April 24th of
too long
year. It's too long. Well, if there's one thing we've quickly learned about Laura Owens, that I have anyway, that is she waits till the last minute to do everything, including this Uber lawsuit that we're about ready to get into. But yeah, so she was offered a plea deal of some sort, has till then to decide. What do you think about that, Terry? Do you think she's going to take a plea deal?
Part of me thinks with her personality, no, because she's going to want her day in court. But
should she?
Depends on what the offer is.
Yeah, I'm gonna listen. If we find out though that it doesn't involve serving any time, I'm gonna be pissed.
I mean,
all right,
if it doesn't make her serve time, or if it's a suspended sentence, I could see her taking it, because then she would have a guarantee of not going to prison or jail.
She'd be stupid not to.
Be stupid not. Well,
but I was sitting here thinking about it like since yesterday and this morning. Like, if it involves serving time, I don't know if she's going to take it for numerous reasons. One, she's a narcissist. So that means you have to admit that she lied about everything, which then takes her entire identity of the last 8 years and it just falls apart, which is very hard for narcissists to do.
Right.
If she was one, allegedly. I don't know. I'm not a doctor. But also, I don't know if do you think her mom would let her? Because I don't think she would. I think she would be like, no, my daughter is not going to prison. They don't serve House of Prime Rib there.
And she's not going to have that on her record that's going to follow her for the rest of her life.
Yes.
My daughter is innocent. She didn't do these things. She needs to go stand up for herself.
Yeah, I feel like, because if you take the plea deal, you're telling the whole world you're guilty. I mean, that's part of the deal. and I think, so far in our little bit of a journey we've been on in Laura seems to love to be a victim of everything. And you
They
can't quite
offered
be a victim if like,
pleas
no.
for those type of things. Okay, I didn't think so,
Well,
but I was
not in
like,
Arizona.
not in
Arizona
Arizona. Okay.
is guilty or not guilty. That's it.
Okay,
None of
good.
the in-betweens, like
Because I see Alfred
contests. Hi,
that
Helga.
even though I'm not guilty.
So no, it's either guilty or no guilt
Okay.
or not guilty in Arizona. So those are her only choices. And I don't know. I don't
If we
think
knew
she's
what
gonna
the
take
plea
it.
deal was, I could make a better thing. But if it has no jail time or prison time, she would be dumb to not take it.
I agree.
Because
I agree.
you go to trial, you're going to spend some time.
I mean, I'm a little disappointed that they even offered her one in the first place, to be quite honest with you.
Maybe the victims have been through so much.
Maybe, but listen, we don't know the future, okay?
Yeah.
But this is not going to be the end of her pulling these shenanigans. She's literally been spending years doing this. She's not going to stop if the consequences aren't harsh enough, because as we're about to learn in these next two lawsuits, she gets away with shit without ever having to prove anything. That's why she kept, I think we haven't even gotten through Greg and we haven't gotten through Clayton yet here on our channel. But I believe when it comes to Clayton, the really, big fish, if you will, because of his, career on TV and real estate, is she got all the balls to do that because of how everything else fell, in court ahead of
she has
before
Teflon.
him.
Nothing sticks to her. She is made of Teflon.
Apparently sperm sticks to her uterus constantly. Hi,
sperm
Angie.
Sticks.
Hello, our new friends, Bruce and Hellville. I definitely don't think we're going to find out until that day. She literally is like, I don't do anything until last minute.
Oh, deadline's at noon. It's 11:58. I think you can accept now or decline now.
Yeah, I don't think she's gonna accept it because then you can't appeal. You can't be like, I'm a victim of the government.
Right.
This is all a conspiracy against me, right? Because I do know that that's been part of like her and her mom's narrative.
Right.
There's just this cult conspiracy of people out to ruin their lives. And
I did find on TikTok, they did a little video, probably AI, that it was Wendy Adelson and Laura Owens, and the pictures kept intertwining, kind of like showing they're the same person. And I was like, oh my God, that is brilliant.
I just think if she went to prison, though, in Arizona, she could go to the same prison as Jodi Arias.
Oh my God.
No, Daybell's up in Idaho again. I forgot. She's out of Arizona now and just up there. But can you imagine?
Yeah.
Hi, Hellville. Hellville says her new complex case hearing is April 9th, so she may be told by her public defender to make a choice by then. Yeah.
I mean, sooner's better than later. If you're, gonna.
That's true.
Jodi Arias and her. Oh,
could you imagine?
No. I mean, I would want to be a fly on the wall to hear their conversations, but no, I don't think the world can handle that kind of insanity.
Me either. But I mean, I personally, and again, I'm just kind of annoyed that they offered her a deal because one, I'm selfish and I want to watch the trial. Okay. But two, her shenanigans, while the world is talking about it, like so many people still don't know about this. What if they were cellmates? Oh my God. I don't even know what laugh that was.
I mean,
they need to blast this. All right. I know that some people know, but all of the true crime do not know. And her shenanigans need to be broadcast nonstop because there will be other victims.
And if there's a plea deal, I'm hoping it's at least half of whatever they think that she could actually get. Because, I mean, she should not get off easy. she should not, because she's going to even cause problems from behind bars.
I think so. I mean, oh my gosh.
I mean, then she's going to wind up pregnant by one of the guards.
Right? Think of all the staring, Terry. All the stares. Gonna make her afraid, scared. Yeah, right? Hellville, to accept the deal, she has to admit she's guilty, and she's incapable of that. Yeah, I think so. I do think that this is a mercy offer. I think they're being real nice about it. Okay, because one, you don't see a lot of people charged with perjury. All right.
No.
Even when you know it's happening, it's very hard because you have to be able to prove that they intended to lie. And I mean,
she doesn't know how not to.
Right. So the fact that these charges have been brought against her, and it was recommended by a judge that they filed charges against her. It's pretty solid case. I think this was just like a mercy of like, either do this or we're going to blow your shit up in court.
Maybe the prosecutor feels bad for, the victims and the public defender. No. Maybe he's like, you know what? We do not want to have to subject her to anyone else.
Oh, yes, that's true. She's not just charged with perjury. That's correct. Yes, she's already admitted to forgery and tampering with evidence. Yeah, I mean, she is fucked.
She is. And not in a way that's going to get her pregnant.
No, not at all. User QQ. That's just what I'm going to call you. QQ. She might need a free place to stay for a while. Yes, because also there's always news coming about this every day. Her parents' house is going to be foreclosed on in May. So she has to move out of the casita.
I saw somewhere when I was scrolling in the middle of the night the other night that somebody had started a GoFundMe to raise money for her, but it like got taken down like very quick. And I was like, yeah.
Oh, is that today, Hellville? Oh, I didn't realize it was coming this soon. Hellville says there's a new podcast drop today. Love Trapped should be interesting. I'm excited to listen. Ooh, I'll listen to it. I don't know why. I thought that was like further in the future.
Listen when I'm going to my appointments this afternoon, and I need, since you're not going to be on, to keep me entertained.
Well, I might still be. I don't know.
You could be.
But no, thank you for sharing that. Boy.
And I love your screen name.
Oh, Hellville.
Hellville here.
Or did they also maybe offer her this plea deal because the feds were like, we got it.
Oh, so maybe they're offering
right.
I didn't think about that.
Maybe. I wonder.
Maybe.
I wonder if that has something to do with it, because you don't want the feds on your back, and she's not doing great. So maybe that was the reason. We don't know yet. We don't know. I'm so stoked about the foreclosure.
And normally I would feel bad for people losing their home, because that's a real problem.
Sure.
But I'm going to just be honest. I got no sympathy for them, because her mom, I got no sympathy.
Mm-hmm.
I'm sorry.
How much money you spent on all of this?
I know. They created the problem.
Mm-hmm.
I don't think Laura has been held accountable, from my opinion as a mom, for anything in her life.
No, that's what I'm gathering too as we're going along here. Because I was on the fence because I didn't know much about the family.
I was, but not now.
But no, even with her dad's responses to Mike, it was very obvious that just make her be quiet, give her whatever she wants, and she'll be quiet.
If she wants, just
fine. And look,
and that's the problem.
Mm-hmm. And that's why I do feel like there better be some serious punishment here, because she needs that in her life. Do I think that's going to change her as a person? No.
We can hope. We can always hope that it'll be the thing that she will hit bottom if she goes to prison.
And see, that's another reason why I don't think they'll take the plea deal if it involves prison time, because they're, upper middle class rich people, right? They don't associate with the poor who can't afford a table at the House of Prime Rib. All right. And prison is just filled with pores, Terry. Did you know that?
Um, I am sorry to
Just kidding.
tell them, but prison is filled with people from all walks of life.
But I could see them being like, no, we are too good to go to prison. Look at Laura. She weighs 90 pounds. She's going to get beaten. It's going to be
Her,
horrible.
though, make her hers. If she goes to prison.
Oh, don't get me wrong. I don't think she's going to make it. Horse girls don't go to prison. You know,
She absolutely, she would petition to be in the VIP block.
Probably.
Can you imagine when she was like in prison, if she goes and they serve the first meal?
Oh my gosh.
I would love to have that on video because she's going to be like 50 pounds because she is not going to eat.
No, she'll go on a hunger strike. They're starving me. And don't get me wrong, I'm a picky ass eater too. I would die.
Oh, I would die too, but I would at least
yeah.
eat what I needed to stay alive.
Yeah. And listen, the people in prison are used to liars. All right. They will call you on your bullshit, and you may not like how they call you out on it.
It would be a real eye-opener for her, and I think it would be good for her. And if that doesn't straighten her up, I don't think there's anything that can. If a good stint in prison can't straighten her up, there is no hope for her.
Yep, so we'll have to wait and see if Laura accepts the plea deal or not. I don't know. I think
we should do a poll to see what everybody thinks. And
there you go. Yeah, go ahead and start one. Why don't you?
I don't know how to do that.
Oh, okay. Well, hold on.
Nobody has shown me because y'all always say, "Oh, we'll do it for you."
Yeah, open up the YouTube chat.
Oh, I just opened. Okay, well, I know how to do it from there. I didn't know if I needed to do something different.
No, that's exactly how you do that.
Okay.
So.
Look at this, guys. Llama is teaching me how fifth. Does it matter which one I do it in?
Yeah, because they're two separate ones. So you'd have to do it in both of them.
Separate ones. Okay.
Yeah. She'll demand Berry's boot camp be put into the prison yard. I've taken 1,000 boot camp classes. Oh my gosh. Oh. Elville says Clayton agrees prison is the only thing that may stop her madness a little. I agree. I mean, I really do. I do not think, I mean, as we're just about ready to get into these lawsuits and everything that's happened so far, I do think that's the only thing that may make her calm down a little bit. All right. Do I think that's going to stop her behavior? Maybe if it's a long sentence, you know, if she only got the plea deal that's like 2 years, no, I don't think that's going to change her a whole lot. If she gets one that's like 8 to 10 years, she may come out and not try to do all this crazy bullshit, you know, but you never know. You never know.
I do think it's the only thing that would stop her shenanigans.
Well, and, you know, that's another reason why I think the trial should be televised. Because, listen, Laura's not the only person who's done shit like this.
I know. That's
at all. This happens all of the time, you know. Not even just like the fake pregnancies, but taking people to court and using the court to weaponize, you know. And I do feel like that needs to be publicly shared, that, listen, this bullshit isn't being tolerated anymore because the court system is overflowing with stuff. And I bet a good part of it doesn't even need to be there.
Right.
You know? And so
I would love to get a hold of her elementary, middle school, and high school transcripts to see what kind of problems she caused in school. I mean, if anybody went to school with her in junior high or high school, reach out. I would love to know what kind of shenanigans she did back then.
Helville says she needs to be labeled a fictitious litigant. I agree with that. She won her harassment against Rob, and that was ridiculous to say. She won that? Was it just a preliminary one? Because I don't know what an injunction against harassment is. That's like a TPO, right? Like a PO, protection order to some degree. Like, was it the easy first one they give out? Or that's crazy. That's another,
crazy.
you don't know who that, I don't know if you know who that is, Terry. That's another YouTube creator who I was not familiar with until like 2 weeks ago. Sorry, Rob.
So Rob.
Yes.
Yes.
Yes. That's who they're talking about. Yes, that one that I sent to you.
Okay, that I'm like,
Yes, that's wild. That's the only thing she's won since suing Clayton, but no, I believe it's the permanent one. No shit.
okay, I gotta go look that up.
I know, I'm gonna have to. All right, you guys. Well, enough of all the speculation of whether Laura's gonna take it or not, though I'm probably gonna speculate it every single show we have about this because it's all I can think about is she gonna take it? Is she not? I also have really bad luck at picking trials, so she probably will. Because that's how things work. But anyway, so today we are going to get into the 2 civil lawsuits that she filed against companies. The first one we're going to talk about is Owens versus Uber and like a bunch of companies that she filed in 2019. Now, I'm not going to sit here and read all of those court documents for it because they are boring and full of a lot of legalese. All right. So what I did is I just summed them up in layman terms. Okay. Because I don't feel like reading all of that boring shit. It's not as juicy or spicy as our other ones. I promise. As a matter of fact, they hold next to no information. So that's just what I do with those. So we'll be going over those. Now, what you need to know about Owens versus Uber. Okay. She files this in, speaking of waiting until the last minute, Laura. So she files this lawsuit April 4th, 2019, almost 2 years to the day that the accident happened on April 6th, 2017. So 2 days before the statute of limitations. Now, why I wanted to cover this Uber thing is she doesn't talk. She says she has, serious injuries and harm came to her from this car accident she was in 2017. Now, if you match up the date of April 6, 2017 to what we just heard with Mike, she's with Mike and they're just having crazy sex. All right. And she's blaming him for bruising and petechial stuff that I don't even know if was really there. This is when the abuse was really, going on. And so I thought it was very interesting that in all of her shit with Michael, she doesn't say a word about this car accident. Oh, my abusive boyfriend. I was even in a car accident and he didn't give a shit and didn't take care of me. Why would she not complain about that? All right. She didn't at all. As a matter of fact, she said that it was Mike who gave her such anxiety and depression and PTSD. Well, I can tell you why she didn't bring it up. Because all of that could easily be like, well, that was probably from the car accident, lady, not this innocent guy over here. So I find that very interesting. Did she play it that way on purpose? I don't know, but probably,
Based on history, I would say probably is a good response.
Yeah. That's what I would gather. Right. And so she also waited until, after the thing with Michael was wrapped up, the first 2-year restraining order to file this. So, Helville says the seizures could have been caused by the accident she caused or the numerous times she fell off horses, documented on Schnitzel or All the Best. Yeah, I don't think those come up until
later. Mike
comes back, right? Because we didn't cover any of those accusations. She just blamed him for depression, anxiety at first. I'm assuming that when it comes back 5 years later, she's got a whole long list of stuff. Well, actually, But anyway, so she files this lawsuit 2 days before the statute of limitation runs out, of course. Now, Laura in it says that she was a passenger in an Uber driven by Zaid Al-Kurdi. All right. Now, according to the filing, they were in the MacArthur Tunnel in San Francisco when Al-Kurdi was distracted by his phone, slammed on the brakes, spun out, hit a car in front of him, and was then rear-ended by a truck. So a fairly, multiple cars involved here.
Yeah, that's not a small fender bender.
Mm-hmm. Oh, hi, DMT. Oh, by the way, I also want to say thank you to you, DMN, because at the end of the show on Tuesday, you sent a super chat, a $20 super chat, but I was already off, so I couldn't thank you. So I'm glad you popped up around because I was like, I'm going to have to thank them on the next show. So thank you for your support on Tuesday. I really appreciate that. So there's this car accident that happens. I don't know how long or how fast they were going, but you got, a car hitting you in the front and the back. So, okay, this could possibly be legitimate. All right.
Okay.
Why not? Now, Laura, though, she doesn't just sue the driver. She, cast a wide net, as always, and decides to sue all of the reasonable parties that she can. Which includes Zaid Al-Kurdi, her Uber driver, Uber Technologies and its subsidiaries, Razor LLC, the rideshare platform people, Bruce Brogdon, who was the driver of the GMC truck that hit the Uber in the back, and New Forest Products. They're the company that owned the truck Brogdon was driving because he was in a work truck. All right, so...
She was saying dollar signs.
Mm-hmm. Now, you know what? Let me take this back. She does mention she definitely had to be thinking about this then with Mike, because she does say in the documents that we read about Mike that Mike tried to tell her that she should sue and get a bunch of money for the car accident so she can be his sugar mama.
Okay.
So she definitely was thinking about this at the time, but I think she just waited it out. Mm-hmm.
Maybe had trouble getting an attorney to take it too.
Unfortunately, there's not a lot saying exactly what has happened. You have to read between some of the lines, and even that's not very clear. So basically, she said, there was negligence. Both the drivers were careless and failed their duty to drive safely, especially her driver, Al-Kurdi, and that Brogdon was driving too fast. All right, so it's definitely their fault. It's nothing to do with her. And then, negligent entrustment, which was focused at the truck company, New Forest Products. They gave the keys to Brogdon, even though they knew or should have known he wasn't a safe driver, whatever that means.
Okay.
So I don't know how they really knew that. She does not give any evidence with any of the stuff, guys.
Okay, I was getting ready to say,
no.
A bad driving record, a lot of tickets, a lot of wrecks.
No.
Okay.
At least nothing that we have.
Nothing that was
accessible.
No receipts were brought.
None that I could find.
Okay.
This is just her complaint. Okay. All right, which I think is interesting because here we go again. More accusations, not a whole lot brought up. All right. And then she also, wants to sue Uber because she alleges that Al-Kurdi was not actually insured to provide ride-share services and that Uber failed to properly screen him, yada, yada, yada. And I don't think much of this holds up in court anyway. I'm pretty sure it doesn't anymore. But I guess it never hurts to try.
It's like, say, if you throw enough stuff up, something might eventually stick.
Right.
Just like exactly.
Mm-hmm.
Unedited receipts.
Now, in her prayer for relief, which basically is like, this is what I want to get out of the civil suit, right? She says she wants she doesn't ask for a specific dollar amount yet.
Okay.
Go figure. But she wants general damages, so money for her pain and suffering, both mentally and physically, which she doesn't list what that even means for her. She'd also like to be reimbursed. Oh, yeah, this was fun. She would also like to be reimbursed for lost wages or other financial hits. Remember, she's never had a
I was
job,
excited, but
according to the feds. All right. Also, again, she at her bankruptcy hearing, she was like, I've never had a job in my life, which does kind of come up in this, I think. Again, we don't have a lot of details because you usually don't in lawsuits. So she also would like all of her medical expenses paid for, including rehabilitation. But she doesn't list not a single speck of injuries in her civil suit. Nothing.
And no hospital bills or anything.
No.
Okay.
No.
Okay.
All right. She's in so much trouble. All right. So that was basically her complaint. I'm just telling you that you guys were negligent and I'm taking you to court and I'm not going to tell you what's wrong with me yet or how much money I want, but it's all your fault. So great.
Did she file this pro se?
Or
did she have an attorney?
No.
How would an attorney not? I would think an attorney would. I mean, but there are some attorneys out there.
No, she does have an attorney in this one.
Okay.
Gotcha, Pete Ray and McCarthy are the lawyers. So, I mean, I don't know if that's standard. Honestly, I don't read a lot of civil documents to know if that's just how the first one normally goes.
I know that one I sat on the trial that I chose for the jury that was an injury thing. No, it was all listed out. Medical, what the injury was, what the loss of wages was, estimated, no more than, no less than kind of thing. So that is surprising. Maybe different states are different.
Maybe, I don't know. So that was basically her complaint. All right. Mm-hmm. So then the other documents are all the different companies that are basically like, no. No, we have nothing to do with it. A bunch of Spider-Man meme pointing to one another, like, this not me, but you, sort of thing. Like, they're just like, no, we didn't do it. We had nothing to do with it. So that's really all. Like Bruce Brogdon and New Forest, they file an answer to her complaint. Which was basically, again, so what? Like, I don't know what to tell you. This happens all the time. And the first one was very funny because they list a lot of defenses, which is basically all the paperwork is about, is each side listing what affirmative defenses they can and may use in court, right? And the first one said that they were arguing that even if Laura, everything she said is true, the way the complaint is written doesn't meet the legal requirements of the lawsuit, which I thought was hilarious. Like, bitch, you don't even know what you're doing.
Yeah. And neither does our attorney, apparently.
Oh, Hellville. Is this that guy? The Kachik guy? Oh, I know who. Is that the same one? The Joe, I think his name is, who we'll hear about more, that some shenanigans happened. That's who that is. Interesting. Oh, yes. Okay.
Okay, now it's getting better. It's like
all the tea.
See what happens when you start connecting all the little strings?
Mm-hmm. Oh, Uncle Joe. Oh, interesting. So they also then said, hey, this was her fault too. All right. So in California, different states do different things, but in California, think of whatever the monetary winnings are. Okay. It's kind of split up on whose fault is what and how much you pay.
Right.
All right. So if the crash was 90% of Bogdan's fault and 10% of Laura's fault because she wasn't like wearing a seatbelt or something, then she was awarded $100,000. She'd only get $90,000 because she was 10% at fault. A lot of fractions, which I do not love. I'm really not good at fractions. Talk about some math that I am just not good at.
As I say,
it's fractions. Now, so they're like basically whatever. And they don't mention anything. They do kind of point out, like, you know, where is your doctor stuff? You know, like, you didn't go and make things better. You're not even showing that you tried to do stuff. So what are you doing even filing this lawsuit against us, you know? Oh, Montana. Are you from Montana, DM? That's cool. DMN. Nice. Wait, is that?
Yeah, I mean, how can
MT, does that? Wait, is your name Damn Montana? Is that it? I love it. If not, it should be. So that's basically what happens with all the people. They're just like, oh, did she have insurance or not? Like health insurance? Because Razor comes in, one of the Uber subsidiaries, and they're like, well, if she had, you know, the Affordable Care Act, we don't have to pay shit, you know, sort of thing. So, oh, nice.
Well, it also is Damn Montana too, kind of. So
Damn Montana. That's what I'm gonna call you, if that's all right. So they each file this. Guess what happens? They just have a meeting and they settle it behind closed doors. And we don't know what the settlement was. Obviously, it was definitely for some sort of money. Yes, of some amount. But that was it. That was really all that was there, was just.
So they gave in, even though she didn't provide document. Well, I'm going to just have to try that. I mean, you can win without having proof. Okay. Because when I was in a car wreck in California, had to prove everything.
I'm just saying, this is all they had on the Victims of Laura Owens website. So I'm assuming that that's all there is, or at least that was publicly available.
Right.
Perhaps, maybe some stuff was submitted under seal.
Maybe.
Don't know that. Don't know. But within 4 months. Yeah. In 4 months, they settled.
That's fast.
Yeah. So, because what she filed that April 6th. So, rumor has it she got free Uber for life. What
Uber driver would want? Uber, hopefully y'all did not do that, because she sues you once, she's going to sue you again. Unless you made her sign something that if she got free Uber, she can never sue you again.
I've been called worse. That's wild if true.
Yeah, that's wild.
Like, okay. I mean, for Uber, that actually probably worked well for them. They're like, that's fine.
I wouldn't trust her because she'll sue you again.
Right. Well, maybe that was the thing. If we give you this, you can never sue us again for anything. Could be. I don't know. Unfortunately, that's just how civil settlements usually go. They're behind closed doors. I mean, is it annoying? Yes. Because I very much believe transparency. However, there is very good reason. So that way people aren't taking advantage, fraud, things like that. So unfortunately, it actually makes more sense in doing that. So I read your name as damn it. Damn, Montana. So that's really it from the Uber lawsuit. There's nothing else to it.
So once again, she got away with it.
She got away with it. In 4 months. In 4 months, they settled with her. So she's coming off her second high. The settlement should have her banned from Uber for life. They should. But we do know that's not true, because she took an Uber at the end of 2017. She talked about it in her Mike Maricini note somewhere about being in the Uber and she was scared or something. So apparently that wasn't the case. I don't know. But so she gets off this high in 2018 with getting her protection order against Michael. The court believed all of her fucking bullshit, which still blows my mind. Like, I don't even understand.
Yeah.
I really, really don't. And then 2019 comes, just less than a year. Boom. Wins another one. Doesn't even have to do fucking anything for it. This is great for someone who may be a narcissist, allegedly.
Mm-hmm.
All right. So that was really all for that. Now, Lone Cactus construction is a little bit longer. We got some stuff to read for this. This one's a lot different than the Uber. This one has some tea in it, which I enjoy. And this is a lawsuit between Laura and her mom are listed as the plaintiffs, and Lone Cactus lawsuits. I also made a slideshow when we get to like her big ass, what is it? Her motion for summary judgment. It's like a bazillion pages. I made a slideshow to go along with it. So we'll have that if we get to that today. We will be wrapping up Lone Cactus by tomorrow. So hi, Amy. Right? She'd have to admit it. I don't think she wants to. All right. So let's start this off. This puts us in July 1st, 2021. Hold on. I got to go to the right. I got to remember which one it is that I used to share on here. There we go. I think it's this one. Oh, no, it's not, because then Poe covers your face. It's that one. All right. So this whole thing starts off, well, it starts way before this, but once she makes some legal contact, okay? Laura has finally learned to call the police department, which is not good news for the police department.
No.
But she's learned to do that now because, you need all the documentation you can for court. And she's like, well, why not? So she calls the police at like 11:30 in the morning, and they made notes that she believes a contractor is harassing them, trespassed on their property, stole items that occurred last week, but we're going to report it now. And that's what she was calling about. To make this report, she needs somebody to come out because crime has happened. Okay. Hello, I like green. I like green too. She only went after him because he's local. Yes. Honestly, my theory as we go along with this is that they sought them out on purpose to get free work or not have to pay so much is my theory. But I'm getting ahead of myself. Yeah, she hasn't stopped since. All right, so that's just the police report, or I'm sorry, call for service. Nothing too crazy on there. And then we'll switch over to the field contact report. Okay, so they're going out to the house to see, or wherever she is, to see whatever. Would you like to read the narrative, Terry?
I will. Sorry,
Okay.
somebody just messaged me saying there's breaking news coming out of Dallas, and I just said, what breaking news from Dallas? I need to know.
Oh, interesting.
And now they just told me they're not going to tell me until later. Okay, fine, be that way, Catherine. So on 7/1/2021, I contacted Laura Owens in reference a harassment call with her contractor, Sean Roanhorse. Laura informed me that Sean was doing some work for her on her horse property and was harassing her over some issues with payment. And there were issues over things being criminally damaged. Criminally damaged. Okay. Laura also mentioned that Sean had been at her residence and she had asked him to leave multiple times and he refused to do so. In parentheses, this had occurred within the last week. but she's just now calling. I provided Laura with information on gathering an injunction against harassment against Sean and to take him to civil court over damages and payment issues. Laura stated that she would send me photos of the damage to her property, but I have not received those from her
yet. Also, yes, Hellville. Damn it, Catherine. We need the tea. All right.
No, I'm messaging her back, and I have a feeling I know what it is.
See, I think she targeted them too. So here's her already saying, oh, we are going to civil court, bitches. I just need to have the police this time, you know. But was he charged with crimes of stealing stuff? Was he? No, I don't think so. I don't think so. All right. So that's all of that. Now, this one. So this is their amended civil complaint. Her and her mom, Elizabeth Naylor, also known as Jan Owens.
I'm trying to make
or
sure
Jan
I have
Black.
the same one open. Okay.
And then Jan Owens. These people and all their names. Amy Hood says, we know she tried to flirt with this man too, and he was married and didn't want anything to do with that and was professional. I can see that. I can see that. Hellville says, I think he was just trying to take his own equipment back from their house. Oh, yeah. I feel like they were probably nightmares to deal with. And, you know, Laura has 2 court wins under her belt at this time. She's basically a lawyer. So she's like, it's fine. We'll just do this because I've already won twice and I am now vindicated. So I always will be. All right. So
what is the date of this document?
The date on this one is 9/27/2021. Okay. Oh, that's my birthday.
Just wanted to make sure I have the right one. In case anyone needs to know, Catherine's breaking news is that her POS ex is getting divorced.
Oh, well.
From the woman that he cheated on her with, one of the women. But so that was the breaking news.
There you go. Hot off the press.
Karma.
Hot off the press. All right. So this is their amended complaint. The value of this case exceeds $10,000. Yada, yada, yada. They're actually claiming more than $50,000, but less than $300,000 in damages, just to be specific. So a hefty amount. This isn't just small claims, you know?
No.
All right, so it's them suing this guy. All right, here we go. Statement of facts and breach. It's page 3, Terry. I'll read one and then, or I'll read a page and then you can read the next.
That's fine. I am sitting here looking at the one I found and there's like stamps on it. Did you remove that? The one I'm looking at says nope, nope, nope.
Oh, yeah, that was the Canva one I made to go along with the denial.
I'm like going, what is all this? Nope, nope, nope.
Yeah, because there's a response to it that really isn't. It's them denying pretty much everything, you know? And so like I made like a Canva, but I can't get Canva to work this way. So
that's okay. I just was laughing.
I specifically used nope for you.
Like, nope. Love that. Nope.
All right. So this is what they say happens. Okay. And obviously it's all truthful and correct, in fact, because they would never over exaggerate things ever.
Never.
Let me make this bigger for you guys if you're reading along. All right. So they state that the plaintiffs in this case are Laura Owens and Elizabeth Naylor, aka Jan Black Owens, and Elizabeth Naylor Owens. All the names. Who hired Sean and Lone Cactus Construction LLC to work on existing horse facilities. Yes, that's right, guys. We're getting into horses today. And if you're like, are we going to see some pictures of horses? I think we will. Maybe not today, but definitely tomorrow. We will be seeing some pictures of some horses.
Okay.
So that's another reason why I felt like we need to cover it, because I wanted to see some horses.
We need to see some horses.
Now, so they hire Sean to work on their existing horse facilities in Scottsdale, Arizona, because they've moved now from California to Arizona. They buy and sell horses through Quartet Farms, LLC. From now on, the plaintiffs will be referred to as plaintiffs. So they both sell horses or their company. I don't know.
I'm like, does she have to go and move with her parents everywhere? Can she not live on her own?
I don't think she can. I don't think she can.
Okay.
How she'd have to have a job then, Terry.
Yeah, that's true.
And she is a horse princess. Okay.
Okay. So do you want me to take number 2?
Sure.
Are you
Yeah.
okay?
Yeah, we'll just rotate them. That sounds good.
Okay. The defendants in this case are Sean, the owner of Construction
Lone
LLC,
Cactus.
and Construction LLC, a contracting company engaged in the practice of remodeling, specifically with horse properties and the specialized products and structures associated with these entities. From now on, the defendants will be referred to as defendant.
Ooh. On or around December 26, 2020, the plaintiff asked for bids from contractors who were familiar with the specialized products needed to complete the job, which included stable comfort stall mats, true text footing, arena clean, and quick feed horse feeders. I want to preface by knowing I know zippy zap about horses, horse care, all of that. I've only ridden a horse once, and I was like 33 when I learned that ponies were not just baby horses. So
You've only ridden a horse once?
yes, I've only ridden a horse one time.
Okay, you definitely need to come visit. Okay.
I also, Little Llama's dad took us all out for Father's Day to ride horses like several years ago. So we all went and rode horses together, and I had never been one, right? And they're like, oh, we got ponies for the little ones. And I was like, oh, look at the cute little baby horses. And right next to me are like these 12-year-old girls, all right, 10, 12, preteen girls, right? Who started laughing at me because I called them baby horses.
I'm trying really hard to not be judgmental, but you really thought
I really thought ponies were baby horses.
Oh, honey, you are so pretty.
I know. I am so
pretty. Okay. Now, the defendant's company was the only company that submitted a bid and indicated they had the experience with the specialized products as well as working on projects with hunter/jumper businesses of the caliber of the plaintiffs and were awarded the contract.
Okay. Hi, Liz. By the way,
Hi,
glad to
Liz.
see you, Liz. Man, I guess it's still kind of early for you. That is a common misconception. Thank you, damn it, Montana, for justifying that for me. Thank you. In my non-pony world. Okay, what am I on? 5? Yes.
5.
It was later discovered that the defendant had no experience with arena clean, true text footing, quick feed, or stable comfort mats, and that the defendant deliberately misrepresented his knowledge and expertise in those specialized areas to falsely and fraudulently induce plaintiffs into entering a contract with him. I don't know what any of this stuff means. Is this just setting up a house for them?
No,
And
I know
who-
what
I don't
some of it
even.
is. So,
How do you not know how to lay down mats? I don't
I see
understand.
say it's special mats and the quick feed. Think of like an automated quick feeder kind
Okay.
of thing. I don't know what the true text footing is.
Oh, well, you know more about horses than I do, so you'll be our horse expert.
I know more about goats than horses, but
Well, they're the same, right?
they are the same. They're just baby horses.
They're just itty bitty baby horses.
It was also later discovered that the defendant, when asked if
6.
permits were needed, falsely and fraudulently assured the plaintiff that no permits were needed for the job. Plaintiffs, relying on his assurance and false expertise, found out later that permits were needed, and when they confronted the defendant, his response was to double his initial estimate after work had begun.
Oh.
So, thinking back to Aperture, Did they not verify experience, or did they just take their word for it? I mean, I'm just asking from reading this going
They met
forward.
them on Facebook.
Oh,
So.
hell's bells. Okay. All I needed to know.
Helville says she kept changing the terms of their construction. Oh yeah, like they did all of this on purpose.
Yeah, but this is her thing, so we'll see. Okay.
Right. All right. So here, I'll highlight these for you, Liz. Maybe that'll be more useful for you. The original quote from the defendant was $7,320, which was to include the barn, arena, tack room, wash rack, and materials. The timeline given for completion of the contract was 4 days to begin in early February with a completion date on or before February 16th. The defendant was aware that the horses would be arriving at this time and the necessity for the work to be completed. So this isn't supposed to take very long or be a whole lot of money. And we're going to find out that none of that's the case. Because, of course, why would it?
Okay.
Why would it?
The final payment of $7,906 was requested by the defendant on April 6th because he falsely assured the plaintiff that the project would be completed by the end of the day. After payment was made, the defendant then stated he would need until the end of the week to complete the contract. The work was never completed in full by the defendant.
Now, the final amount paid to the defendant for non-completed work was $34,508. Wow. How did we get from point A to
wasn't the estimate 7,000 something?
Mm-hmm.
Where are the change orders? Where are the requests for this?
Oh boy.
Wow. The cost of the plaintiff due to the defendant's misrepresentation, fraud, and negligence included the following. Due to the poor quality of work, the defendant's pony, Tiffany, contracted...
Tiffany. She wouldn't have a horse named Tiffany.
That's a cute name for a horse. Laminitis while on the stable comfort mats that were installed by the defendant. Next, on or around May 18th, it was determined that the instructions for installation of the stable comfort mats had not been followed and that the mats were dangerous. The defendant reached out to a Mr., one of a limited number of stable comfort dealers in North America. He indicated that it was the worst installation he had seen in 20 years. The defendant was then given a second chance to install the mats. The defendant refused to oversee the work and did not communicate with Mr. to ensure that something told the quick feeders were more difficult to install than was initially thought, and that battery boxes would need to be fabricated, which was not done. This was drawn out for weeks.
Which is everything that Laura touches.
Yes.
The quickest thing she ever did was the Uber lawsuit.
Yeah. Finally, the plaintiffs had to hire a handyman for $419, and the correct boxes were purchased on Amazon for $12 each. It was discovered that Mr. storage of these products during construction rendered the feeders damaged and unusable.
I think Mr. is Sean.
I find it interesting. They gave us his name earlier, and now they're not giving it to us. Either give it to us or we don't. The defendant was asked repeatedly to contact the president of the engineering company for instructions. The defendant never contacted them. It was later discovered that the defendant had no experience with Arena Clean, Trutex footing, Quick Feed, or stable comfort mats, and you went up a little too far.
Sorry.
A little too far still.
Sorry.
Had grossly misrepresented his skill set and expertise in December to falsely induce the plaintiff into granting him the contract.
Ooh. I'm just going to highlight these because I'm going to go get coffee real quick.
Okay. Can you bring it down just a little bit so I can see?
Yes, ma'am.
Okay.
There you go.
The repeated delays and the negligent installation of the footing and the additives caused the plaintiff's horses to lose fitness due to their instability to work in an arena. Additionally, the plaintiff could not show their horses for sale at their facility due to there being no area to ride due to the negligence of the defendant. The plaintiff has a business and has sold horses for as high as $150,000. The sales business was unable to operate. Okay. The True Tax footing bags did not get opened by the defendant until April 27th, long after the expected date of project completion. The installation instructions were not followed, and the wrong equipment was used to install it. This resulted in the footing being unusable and riding being suspended until it was fixed.
I'm a little, because I don't know much about like horses and shits. Like, is what they asked him to do even complicated in the first place, or?
I don't know what they're using the sure fitting because they're wanting, it sounds like, to put it in the arena for them to ride on. Can't they just go on dirt?
I don't know.
I don't know on that one either. So, in addition, the defendant was asked via numerous communications,
I'm sure,
when the extremely strong canvas backing that he ordered was going to be installed. The defendant repeatedly told the plaintiff, today, each time. Yet the day of installation never came. So dramatic. In a desperate attempt to keep the horses safe from the elements, the plaintiffs ordered a canvas backing on June 5th, which blew down and could have caused a tragedy.
One, what would the tragedy be?
I know. I'm like,
Two, this is supposed to be done in February. We're in June now.
Yeah, okay. On May 30th, the day when the defendant allegedly sprayed the arena clean, the plaintiffs discovered that not all of it was used and that the remaining amounts had been taken away on the defendant's trailer. The defendant had originally instructed the plaintiff to get enough for 110 by 140 ring. The plaintiff's rings are 110 feet long by 80 at the very widest part, with most of it being around 50 to 60. The plaintiff ended up with a dry ring when it should have been soaked, given how much extra was purchased. Additionally, the arena clean was carelessly spread on the plaintiff's dividing wall, eucalyptus trees, stalls, intact trunks, covering them with oil.
Oh, baby oil? Just kidding. It's not a freak off, guys.
It was discovered with witnesses that several items were taken by Sean and Blank LLC, including a drum of arena clean, which was approximately $508.
Having horses is expensive.
It's expensive. The
Do
defendant
they still, hold on, question for people who have been following. Does she still have all these horses? Like, is she still going strong with the
bankruptcy and can't afford her parents' house? I mean,
well, yeah, that's what I'm wondering. Like, if they're in foreclosure, like, does she still have
I don't know.
all of her horses?
I don't know.
Oh, don't worry, you guys. We're gonna get text messages that we're gonna read, write-ups by Laura, emails, pictures. Don't worry. There is surprisingly, somebody actually submitted a bunch of evidence. Whether or not it's actual evidence, I don't know about that, but Jan did mention Diddy. That's true. I forgot him and the Long Island serial killer. I forgot all about that from the investigation.
Oh my gosh.
Oh my gosh. They are something. They have 7 or 8 as of February 9th. Oh shit. She still has them.
Well, then
Oh,
she needs to sell them to pay some bills. Horses are not cheap.
no. How do you have so many horses?
Well, they're selling them, so maybe they're training them. I mean, I don't know what she's doing with them.
When does she have the time to train anything? She's busy writing law shit all the time.
The defendant was told many times that the horses were getting injured because of the quality of welding that was done. The workers even admitting to being new to welding and that they were making many errors due to their inexperience.
Oh, here we go. Okay.
The original foreman of the project was fired. The plaintiff was told by one of the defendant's crew members that a big reason for the foreman's termination was that he had made mistakes on our property.
Oh.
These admitted errors resulted in one of the plaintiff's horses getting his hoof caught in the fence, and 4 of the horses have had cuts that will likely score due to the wire not being filed down. That's not good. The defendant cut a large section of the fencing out where the cross tie was to be installed, causing the plaintiff's most valuable horse to escape the area where the fencing had once been and to become stuck in a small gap between the plaintiff's arena fence and their neighbor's wall. This could have caused a major injury, if not death, due to negligence on the part of the defendant. I mean, if all of that's true, that could,
But she did say, hey, they said they didn't have experience in welding and stuff. So, like, isn't that kind of your fault for hiring people with no experience then?
Yeah.
I mean, I'm just saying. Aren't you a little negligent at a certain point, maybe?
Mm-hmm.
I don't know. All right. So they go on to say the defendant engaged in harassment and trespassing. Oh, I bet there was so much staring, you guys. Trigger warning. There may be incoming staring. Just to let you know. I don't know. The plaintiff warned the defendant on several occasions to cease verbal conversations and to instead keep to texting or emails so that there would be a written trail of communication. The defendant was told not to return to the property. However, on the morning of June 19th, the defendant showed up at the plaintiff's property at 6:50 a.m. Rude, I'll be honest.
That's
Ew.
rude.
And entered the horse facility through their driveway. Oh, are the horses on the...
It's probably like
property?
if you own acreage, like our goats are in the back 40, they could have their stables next door, then the riding arena, the barn, the tack area.
Oh, okay. So they're all connected together.
Could
Okay.
be.
Listen, people don't have a lot of horses in Ohio. Okay. I know some of you in other states, you're like, horses are everywhere. Not here. Not really. No.
Along with the snakes.
Yeah. Now, where was I? All right. So there were several workers on the grounds who asked what the defendant was doing. And he stated that he was looking for Laura. Oh, chilly.
How dare he?
The workers instructed the defendant to leave, but he did not comply and instead left the horse facility to ring the doorbell at the plaintiff's residence. Oh my gosh, the horror. The defendant claimed he wanted to discuss with plaintiff invoice questions. Oh, how dare they?
How dare you?
Right. I apologize. Laura's never negligent over anything ever. Oh my gosh. It's not even, she does say that in her body.
I mean, I will say that's a little early.
So rude. Oh my gosh. But ringing the doorbell. Oh, the audacity.
Bring it down a little bit. I can't see it
sorry.
because of the heading.
Sorry.
During the conversation regarding how the defendant was going to reimburse the plaintiff for damages incurred, the defendant admitted fault and explained that he would pay the requested, which was at that time $33,447 by June 21st. The plaintiffs gave the defendant a deadline of 5 p.m. on June 25th, yet payment was never received.
Oh, no.
The defendant was advised that fees would continue to mount over the weekend and that the plaintiff would investigate his work to determine if further charges would be incurred.
Can they do that?
Well, it's Laura Owens. She can do what she wants.
I mean, is that like a thing though, where it's like,
Yeah.
well, I'm going to add $100 each hour?
Is it in your contract? The defendant did not acknowledge this. On June 28th, payment request for $44,441.43 was requested after further evidence was gathered.
Wild. Let's see. The defendant has ignored all requests for updates in regards to payment or demands to see the contract. Multiple requests for the defendant's insurance company information were also unanswered. I mean, okay.
The registrar of contracts was contacted and a complaint was filed on July 7th. Plaintiff was informed by an investigator that the ROC would not be the best route to go in order to get reimbursement. ROC is the registrar of contracts. He explained that the ROC can only get contractors to fix or complete work, not reimburse for poor work. Given the many chances given to the defendant to complete the project correctly, in addition to his trespassing and his harassment,
Of course.
more explained below, it was determined that civil litigation was the best route.
So let me get this. All right. So they go to the ROC. All right. To do this complaint. And they're like, listen, we can only get contractors to fix or complete the work. Like, we can't help you get your money back, but we can get people to help you finish it. Right. And they were like, no, no, thanks. We just want the money. Okay, great. Thanks. Bye. Like, what about your horses?
Like, because if your horses are really getting caught in the fence, you would be like, oh my God, thank you for sending someone out to take care of this.
Yeah. Because would they get to come out and do it? I wonder. I don't know. I have so many
I can't wait to see the contract because we started at 7,000.
Right.
They kept adding stuff.
And of course, harassment. I'll tell you what, Laura Owens gets harassed so much. It's wild.
She should change her name to Laura Harassment Owens because she gets harassed so much. It should be a nickname.
Oh, we'll get to it in a couple of years. She does try to change her name.
Oh, shit.
She does eventually try to change her name.
Oh,
it doesn't work.
My Lord.
It doesn't work. Yeah. I don't remember which year that is, but I think it's during Greg and Clayton. It's somewhere in that area. We'll get there though. All right. So they say they have a promissory note, terms not met, contract requirements, provisions of documents and receipts of contract signed under duress and never received a copy. Okay. How is it
What do you mean
duress?
it was signed under duress? You're the person purchasing it.
Right? Like, I don't even know what that means.
Oh my God.
I think autumn 2023, Emily Laura Wilson was born and died. Yeah, it was definitely, I know Clayton was around. So yeah, that would be 2023, wouldn't it? And then she decides.
Just when I think this bee cannot get any crazier.
That's what I keep telling you. Like,
I know. And I keep telling you, we have other work that I need to work on and I got to listen to you. And because this is just I need the tea.
And then, of course, claim 3, the plaintiff selected the defendant as contractor because falsely claimed expertise in installation of stable comfort mats, arena clean, and true text footing, fraud, deception, and false pretenses. What a bastard. Claim 4, breach of contract acted in bad faith. Claim 5, construction defects, foundation, stalls, arena, fencing, and roofing. The defendant was given many opportunities to fix these things. The materials purchased by the defendant have proven to be subpar and defective. I thought they were purchasing shit, but okay.
But nowhere did you say you were putting in full stalls and fencing. You were just asking for a rapid feeder, some cleaning stuff. Okay.
Claim 6, recoverable damages, direct damages, economic waste. The plaintiff had to purchase new materials and hire new laborers to redo the work that was supposed to be completed by the defendant and continues to need to do so. So the fuck going to ROC where they could, like, I don't know, help you. You're like, nope, I'm just going to buy stuff and hire some new people who I imagine was a nightmare for them. But no, I don't want a quick fix. A fix that makes sense. No, let's go to court. It's my favorite. Claim 7, faulty workmanship. The construction did not hold up well to monsoons and was completely flooded each time one happened. Is that something y'all can really prepare for?
Well,
I mean, that's just a lot of, what are you supposed to do?
If you know it's going to happen, you need to make sure that there's proper drainage so that their stalls don't fill with water.
Oh, okay. So there is something you can do. But also at the same time, there's just like not a lot you can do.
No, you just have to have proper drainage.
Okay. Anyway, it was completely flooded each time one happened. The contractor was negligent and had knowledge of this. The barn was built inside out with the poles made to hold up the barn being placed outside rather than inside of the roof structure. The workmanship on all specialty products is correct. So if you notice that the barn was built inside out and you didn't say nothing when you know what these barns are supposed to look like, probably. Okay. Claim 8, building permits, local proof of valid license, violation, gave an estimate knowing that the quote provided for the work would not be permitted. The plaintiff asked if permits should be applied for in December ahead of work, and was told they were unnecessary by the defendant. Well, probably from the beginning.
Because maybe the original mats and stuff like that, you didn't need it. But if you're building actual structures, you need permits.
Yeah. Claim 9, they want recovery of all legal fees, of course. Claim 10, emotional damages. Oh boy. The defendant, knowing the serious health issues that the Owens family was facing, claimed he would complete work quickly so as to not add more stress in their lives. Do they know who they are?
Yeah.
He delayed work, fabricated 50 plus stories for the delays. Oh, really, Laura? Okay.
Well, then you should have been right up your alley.
Right. And repeatedly said he would show up to work when he did not. This meant that the plaintiff's schedule was determined by the defendant as if they had anything going on in their lives.
Right.
In addition, the stress of needing to find stabling for Quartet Farms LLC's horses was innumerable. The defendant trespassed and attempted to find the plaintiff, Laura Owens, in her casita on sorry, the casitas. I've been watching the Nancy Guthrie stuff, and Nancy had a little casita as well.
A casita. So
between the casitas and the javelinas, these are just words I've never heard before, and I love them.
Casitas are a popular thing. California, Arizona, Vegas, Hawaii.
Is that just a fancy word for a guest house?
It is.
or mother-in-law suite, or whatever they want to call them.
Yeah, or a cottage.
Yeah, but those are my two new favorite words I've learned. Casita and javelinas. Where was I? Oh, so on June 19th at 6:50 a.m., after she told him not to come on the property, this harassment attempt frightened Miss Owens and caused insomnia and anxiety. Uh-oh.
Because somebody knocked on your door?
Because somebody knocked on her door.
Oh, my God.
The
How dare
plaintiff,
they?
Elizabeth Naylor, also felt unsafe after he knocked on her door at the same time without any notice of his impending visit. Oh.
Oh, the audacity of people to knock on a door.
I mean, I do freak out when people knock on my door. I will like sneak up like a ninja to my people to like see who it is, which is never anybody I know. And then I just wait for them to leave. I do not like people knocking on my door. But you know what? That's my problem.
Considering it was 6:50 in the morning and workers told him to leave, it's not like they were in bed. They
Right?
already had workers on the property. It could have been one of their workers to come and knock on the door to tell them something was wrong with the horse. So
Right?
why are you freaking out?
Because the drama. The negligence shown by the defendant have led to several injuries to the plaintiff's horses, including an episode of laminitis.
Laminitis?
I don't know. Injuries to the neck and legs of several horses who escaped due to defective locks they installed, but they couldn't possibly be running away from them. I mean, go be free, horses, go be free. And severe thrush to 5 horses caused by water damage, incorrect leveling and construction of the barn. Mr. Sean, I think, has laughed at the injuries and has had ample time and opportunity to fix these issues to prevent further injuries. His actions show a total lack of concern for the animals and are the definition of animal cruelty. Okay. Right. Then why didn't he get charges pressed on him?
I mean, I have to say that Laura does a great job of writing some dramatic court documents. I mean, she gets an A for the drama.
That's true. Ooh, demand for relief.
Okay.
Plaintiff demands $150,000. The defendant admitted fault when agreeing to pay back the full amount to the plaintiff. The rest of the damages are costs of materials and labor needed to fix his workmanship, as well as supplemental expenses paid by the defendant for vet bills and a conservative estimate of loss of income of the sale business, which has been unable to operate near capacity since the defendant's involvement with the plaintiff. Emotional damages are very conservative.
Okay. Earlier, she said they weren't able to conduct any sales business.
Right.
Now you're saying they're unable to operate near capacity. So did you operate or did you not operate to full capacity? Which one is it, Laura? I need to know.
Well, she doesn't know the difference between a CEO and a manager, though. Terry. Gosh. I can't believe. Okay, wow. The plaintiff's business. Oh, yeah, go ahead. You do this one. Sounds great.
The plaintiff's business, Quartet Farms, LLC, was not able to operate during the time that the defendant was working at the property. The plaintiff has had as many as 13 horses for sale or lease at any given time since it began in 2014. During construction, there were no facilities available to house or train horses. Thus, no opportunity to accumulate more horses to sell.
But did you sell any of the other horses?
Yeah.
To make room to buy new ones? I
know, like, did you? Mr. Sean, I'm guessing, left the project dangerous to animals and only one horse could be kept for sales purposes from when the property was purchased through September 27th, 2021.
Yeah.
Okay. The property was bought specifically to expand the operation. The average price of a horse sold by Quartet Farms is $50,000, with the highest price being $125,000. I thought you said 150 earlier.
Well, let's write down those numbers for the foreclosure bankruptcy hearing, shall we?
I thought she said 150 earlier. Given that the goal of the company is to sell one horse per month, the potential loss of income is about $50,000 per month, or $250,000 plus during the time that the defendant was supposedly completing work.
Question for the chat and veterans here. Do they have a history of actually selling horses? Like, do they? Or do they just have horses and say, oh, we're going to sell them, but never actually do that? Like, wait, do they? Because I'm finding this to be like a shakedown. Because I don't understand why you still can't sell horses. Like, why can't you do that? Did you see the suit against her for selling a fraudulent horse? No, I do not know about that, Helville. Please leave the deets, and I will definitely be looking that up. What? All I've seen is Laura collecting old knackered horses. Oh, so they're not even like ones you're going to get a good price for. Sorry, horses. I think you're very important too, but let's be honest. I doubt that you're worth a lot of money. There's a difference between selling a horse and selling horses as a business. That's true. Hi, Lady in Gray. Hello.
It's a huge difference.
They buy bad horses cheap, train them, and sell them. They flip horses. I didn't even know that was like a thing, but okay. All right. All right. Oh.
Not for $50,000 that I'm aware of.
I didn't even know a horse cost that much. That's crazy.
Oh, they can.
I mean, I guess it makes sense, depending, I guess.
Wow.
Like if they're race horses or police horses.
The negligence shown by Sean and his crew have led to several injuries to the plaintiff's horses, including an episode of laminitis, injuries to the neck and legs of several horses, and severe thrush to 5 horses caused by water damage, incorrect leveling and construction of the barn, and others detailed in Claim 9. Okay. The plaintiff still has tens of thousands of dollars in repairs to make due to the negligent construction.
Which, you have the ROC that would help you do this. I don't understand.
Yeah. It will go on for several months, if not a year or more.
What? Get out of here. Oh, my God.
Resulting in further loss of income from sales, horses, as well as potential injuries.
Oh, I'm going to look at it. Thank you for letting us know about this horse drama. Of course. Horse fraud. I didn't even know that was a thing.
I did find there's a thing about the fraud behind it.
Oh, well, I'm going to be looking into that.
Okay, this next part. Okay. Number 5, knowing that the plaintiff was in treatment for epilepsy and depression, as well as her father being in treatment for cancer, had Parkinson's for 21 years, and had an upcoming surgery for a heart valve repair. The defendant took advantage of the situation with no compassion for other stresses in the Owens family's lives.
How dare he?
How dare he?
Hi, Lainey. Look at you making it. Hi, Lainey.
The defendant also lied several times about his own personal situation to gain sympathy, including saying that he had children. He did not. And that they were both in treatment for cancer when his repayment was due.
Okay, Laura. He lied several times about his personal situation to gain sympathy. Says you, ma'am.
That is the hot calling the kettle black.
Wow. Nobody else can do it. I do. It's fine if I do it, but not anybody else. Why do I feel like that's not even fucking true?
The defendant was
she had no compassion. Let's be honest.
She doesn't know the word.
Right. Dan Montana. Why would the contractor know any of this? They shouldn't. They should have probably. But
yeah. The defendant was aware that in order to make this project work, a loan would need to be taken out. He showed no concern for taking money that he knew he was not owed and from a family that was dealing with serious health issues. Then don't freaking contract somebody. That's not their problem.
Right.
Oh, I'm getting livid now.
Like you taking a loan then why are you doing this in the first place if you didn't have money for it? Just saying. Why all of this? Oh, Amos, gifting 10 new
Amos.
memberships. I didn't even know you were lurking. Hi, babes.
Amos, I still like to call you a miss because you're always a miss at something.
Congrats to all of the new members.
Yes.
We have lots of member-only content, including our 2 shows, TMI and Llama Learns About, which I'll have tomorrow. I'm very excited about it. So, no, none of this is. Oh, look, Hellville got gifted one. Love that.
Love that.
Starboy. Love that name. That's great.
I mean, the contractor is lucky that he didn't wind up getting her pregnant from him knocking on her door. I mean, it could happen, guys. I've learned that with Laura Owens, just a knock on the door.
Right? Oh my gosh. Staring. Yay. I love that for you guys. All right. So let's see. We're at 6.
Number
here.
6.
All right. The defendant was grossly negligent in that he had several opportunities to fix his poor work and chose not to. Never mind the fact that we told him to stop coming around. His actions were intended to cause harm as he laughed at horses escaping from his poorly constructed stalls, saying it was like they were playing musical chairs escaping. What a fucking dick.
I would have appreciated the humor in the moment, honestly.
I know, right? Gosh, she loses her shit over stuff that literally doesn't, like, any normal person knows it's just joke and just trying to put a spin on a bad situation. You know?
They can get out and completely run away and there's not some enclosure, but considering the horse was caught up against the neighboring property's wall, it's not like they could go run out into the open land. It doesn't sound like.
No, but they could have. They could have wings, Terry.
Maybe they're unicorns.
Maybe. He said this was no concern for the health and welfare of the animals, nor for the plaintiff's business. The defendant has acknowledged a poor job already by writing a promissory note to refund $33,447.57. Therefore, he has already acknowledged that every piece of his work was not done correctly. The damages placed on top are extremely conservative. Okay. Oh, thank you, Lady in Gray. Also, for 10 gifted memberships. Oh, you guys are so nice today. We're going to have some new friends.
At 6 a.m., what a great time because March is packed for the members.
Right? Right? I love that. Let's see. She also goes on to say, congrats to all new members. Make sure you check out our member-only stuff. The emotional distress that is caused cannot be put into words, even though I'm going to write all of the words. It's going to be hard, guys. Every day, there seems to be a new problem that arises with Sean's poor workmanship. Oh, my God. On 9/27/21, the North American representative for Stable Comfort Mats reviewed current photos of system. He was shocked that there were divots and ridges on the ground and said he had not seen that in his 20 plus years as one of the country's top stable flooring experts. Oh, I'm sure that's real. Bullshit. I don't believe it. I don't believe it. Mr. Blank explained how Mr. Blank was generally unavailable and on the few occasions he spoke with him, did not attempt to follow his instructions for installation. He explained that the way they are installed places more of a risk to the horses than a benefit and puts them at a high risk of soft tissue injury. This explains the stiffness exhibited by Quartet Farms LLC horses, especially that of Sirocco 91, who has needed backhock, fetlock, and coffin injections since he arrived at the facility in April 2021. Is it because of that, or is he just an old-ass horse?
I don't know.
I don't know either. Sirocco 91 is the competition horse for Ms. Owens. Oh, and a long-term investment for Quartet Farms LLC. So kind of a big deal, I guess. He was named Oh my gosh, she does the same for a horse that she does for her dad. He was named the best equitation horse.
I
don't
know. I'm like, what is that
Equitation
word?
horse at the USET Equitation Finals in 2018, which is the top honor an equitation horse
Is
can
is
receive
it an
in this
equestrian horse?
country.
And she just can't spell?
Maybe.
Maybe,
A
okay.
national equitation finals winner can sell for up to $1 million. Mr. Blank said that to make a horse like Scirocco 91 comfortable, the entire system will need to be torn out and redone. The cost to do this is $27,000. Oh. Similar recommendations were made for the arena, which was completed by Mr. Blank, who had no experience constructing top hunter jumper arenas, despite his initial claims. The foundation base that was installed by him was not leveled and is as deep as 4 inches on parts of the ring, while as shallow as 1/2 in the others. It should be 2.5 to 3 inches throughout with no unevenness. The price to fix his work, meaning removing the footing, redoing the base, placing new true text footing, purchasing the correct type of sand. The wrong type was purchased by Mr. Rowan Horse, and arena clean is approximately $65,000. The end of that. But also, how is it that much when you said it was going to be $7,000?
Exactly. And you said it costs 500 or something for the barrel. I also want to know if however, is the only horse competition in which the rider is the only one scored, not the horse, then why would the horse sell for so much money? I'm
Oh,
mostly familiar with cutting horses. So I'm like, why would you need an expensive horse if you're only scoring the rider? And if the drum was only $508 or something, why is it 60?
right? I've never heard so much bullshit in my entire life. It's just crazy. This got out of control real fast. Real fast. Hi, 80s. Hope you're doing well. Alyssa says she won't take a deal. I think she's referring to the plea deal from earlier, and I agree.
I think Amy Hood, that is interesting.
Amy says in her bankruptcy that she insinuates the horses are not worth a lot. Well, interesting.
Somebody take these documents and mail them to the bankruptcy court. Attention, the whoever administrator who handles
they already got him. They already got
I hope so.
I'm sure. I'm sure. If there's one thing the feds are good at, it's money and getting money and being tedious as fuck about money. So
She contradicts herself throughout this petition.
Right? No, I think so. Like they filed an answer to her complaint, which was mostly just no, we deny everything. And that's pretty much
Feel
pretty
better,
standard.
Kelly. Pneumonia
Hi,
is not
Kelly.
fun. Please feel better.
See you next Tuesday is rich, and I don't mean wealthy. Oh, she sure is something. Horses are Horses are both worth money and nothing. At least one of those things is wrong. It can be both in Laura's world because her sky is a different color than all of ours.
Depends on what the reference is. Bankruptcy, they're not worth anything. Trying to get money for suing somebody, they're worth a lot. I mean,
now we're going to go ahead and start to get into, we may finish it today. I know Terry has to leave early, but I don't have to. So she writes, you're going to want to pull this one up, Terry, because this is the one that has the slideshow. So I can only put one of the two on the screen. So,
what's the label of it?
It'll be the motion for summary judgment. Oh, no, I don't want to download. I want to present. Un momento, please. Oh. We're professionals. It's fine.
Hold on. Let me.
Presenter review.
Summary of relevant facts.
No.
Then let me go back into the guide, and maybe I missed it. I have the answer to the plaintiff's second amendment. Motion for summary judgment, that one. 154 pages?
Yes.
Okay.
That is the correct one. Hold on. I gotta. It's being so annoying today. So she files, it's only 31 pages of writing, guys. The rest is all exhibits, like 200 pages of
The
exhibits.
mumbo jumbo.
Yeah, so the reading's a little long, but what I did, because in her reading, I'm sorry, in her motion for summary judgment, she's like, oh, this is exhibit, 13 and 14 or whatever. So I made a slideshow so we can just casually see what she's talking about as we're reading along, instead of just being like, what was this even supposed to be? And we're like, I don't fuck if I know. Because it's funny, some of the stuff is just blank pages. Like I don't really understand why that's the case, but it was.
I'm downloading them.
Okay, now I got it working. There we go. All right, so we will have that pop up when we need it, I think.
Canvas being a brat.
Yes. Yes, it is. All right. So I wish it would show. No, it doesn't want to do that for me either. That's super great. Sorry, guys. Bit technical difficulties for when I need to switch us back to the other one.
It's because Laura Owens, even the computer is like, what is this insanity?
Did we experience any of that weirdness yesterday in live chat? No, because it happened at night, so I wasn't on yesterday at all. They were only chatting in German. I heard that there was Spanish too. Like it was very strange. That's wild. All right, so let's get into her motion for summary judgment, which is basically like, Judge, how about I'm going to tell you all this stuff and you just go ahead and make a ruling on it. Okay? That'd be great. All right. So I bet Greg tagged YouTube. I bet.
What page are we starting the reading on? Because I downloaded it. Page 1.
Yes. And it's like double space, so it's not really as long as it seems. All right, so I'll start first. Blah, blah, blah. Laura Owens and Elizabeth Naylor move the court for the summary judgment. Blah, 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 blah. That's not important. All right, notice. This motion asks the judge to rule against you without holding a trial. Does she still have lawyers in this one? No. Oh, look at this. Look at this up here. Pro se. So Laura is doing this herself.
She is an attorney.
She's basically a lawyer now, guys. Okay, this explains a lot then about this whole thing. Okay, I did not see that. I thought the pro se didn't start till we got to Greg, but very happy to be wrong. Okay, so where was I? So the motion, I forgot I'm not sharing the document with you guys because we have that thing. Anyway, the motion asks the judge to rule against you without holding a trial. You have a right to file a written response to this motion. You have 30 days, blah, 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 blah. For facts, that stuff's not important. All right, summary of relevant facts. There we go. Sorry.
Tell me when you want me to pick up. Just let me know.
Well, we can do numbers. Okay. So I'll be odd numbers again. Okay. The plaintiffs in this case hired defendant to work on their existing horse facilities at their home. The plaintiffs do not run a commercial business, nor do they engage in the practice of boarding, training, or lessons from the public. They only house their own animals at the property. The plaintiffs have 6 of their own hunter-jumper shows, sales, and retired horses, and were looking for a contractor to remodel the horse facilities on a residential property they had purchased. What didn't they just say? They lost all this money, won $150,000 because they sell
Right.
horses, right? Is that not how that works? Okay, fine.
I would think so. The defendants in this case are a contracting company who advertise on Facebook that they practice remodeling, specifically with horse properties, Exhibit 1 and 2.
See, guys, there we go.
And
Awesome. Hold on. Go ahead and finish that.
Okay. And the specialized products and structures associated with these type of entities.
No, they haven't. It's so funny. They're so funny. So here's exhibits 1 and 2. As you see, that's why I did this, because she'll be doing this the whole time. This is the Facebook post by the contractor, right? And they fall into this guy. So, though I must say, their thing is very confusing. Their grammar's not great. There's a lot going on with this company, as we'll see. But all right. So then I gotta let my dogs out. So why don't you continue?
Okay.
Waiting, because Zoe, you know how she is.
On or around December 16th, 2020, plaintiff asked on Facebook for bids from contractors who are familiar with high-end feeders, footing, and stall flooring products needed to create top quality accommodations for their horses. Okay. Number 4, the defendant called the plaintiff regarding her posting. The defendant's company was the only company that submitted a bid and indicated they had the experience with specialized products necessary, as well as previously working on projects with hunter jumper businesses of the caliber of plaintiffs. Relying on this information and low bid, defendant awarded the job. The defendant sent photos of what the barn would look like when completed to the plaintiff. The defendant attached a photo in every invoice to the plaintiff of what the end results would be for the plaintiff's barn with wood, an overhang, and a tack room. See Exhibit 30. The end result was nothing like this. See Exhibit 121. We'll wait for Llama to get back to see if we have those exhibits. That's interesting. So he sent an invoice or he sent the invoice and he sent a picture of the barn would look like. Okay, so he must be invoicing up front, is what I'm gathering.
I'm going to have to let her back in.
Okay, I didn't know if you wanted to show exhibits that were mentioned.
Yes, sorry. Where are we?
Exhibit 30. This is supposed to be what the end result for the barn, what it would look like.
Yes. So these are messages from her to Sean that say, I have 5,000 pounds. This is in March 16th, by the way. Remember, they said this is going to be done in February, March 16th. She being Laura, messages him, I have 5,000 pounds of arena clean coming tomorrow between 1 and 5. Just found out. Some pictures of horses. And this is the contract for Jason, who sold me the stable comfort mats. So there's that one.
Yeah. And then it says Exhibit 121. It said the end result was nothing like this. See Exhibit 121.
There we go. Apparently nothing like this, but look at the cute horses.
I say the cute horses.
We do get to see the cute horses. So
now we're at number 5.
She didn't check references. I know. But she never does anything wrong. So the quote given to the plaintiff by the defendant was $7,320 on December 16th, 2020, which was to include the barn, arena, tack room, wash rack, and materials. The timeline given for the completion of the contract was 4 days to begin in early February with a completion date on or before February 16th. Defendant was made aware that the horses would be arriving at this time and the necessity for the work to be completed on schedule. Oh, there's Zoe running in all of a sudden when it's a good time for her. It should be noted that the defendant has claimed to be unable to find this estimate on his computer. Here we go. Can you see that well enough to read it or no?
I can. I'm still trying to figure out what the 7,000 estimate is for. Then it says, and what is the rest? The amount I need to know from above. Could we use complete sentences, people? Okay, got it. We'll get to it after I leave appointment with my daughter. And she replies, ? Really need to know. He responds, working on this today and we'll have most stuff by tonight. Still working with this invoicing company, but should have all other items by tonight. Which she replies, do you have the info? I need it by the late morning, or I will estimate so that I can have this written out by the end of the day. Which he replies, okay, we'll have it to you shortly. We still got no new info from invoice company for the 7,000 estimate, but we'll have the rest shortly.
Which, by the way,
he says he's at a doctor's appointment with his daughter. He can't stop what he's doing to give you what you need. Sorry.
No, you're fine. Where are you?
We're now number 5. I was reading the text messages on the screen.
Oh, that was okay. Sorry.
When you said if I could see it to read it, I thought that's what you meant.
Yeah.
Okay.
I just didn't see thing about the kid.
It is. It was. I will get it after I leave my appointment with my daughter.
Oh, I see. Okay.
I'm like, don't start gaslighting me.
No.
Laura,
No, you're fine.
Mama Laura, don't you do that.
How dare you? How dare you? Man, Shannon approves. Hi, Savage. Hi. Okay, so on March 10th, 2021, by the way, that conversation happened June 8th, 21. So several months after that. On March 10th, 2021, soon before the construction began, the defendant emailed the plaintiff a new invoice that, while dated December 16th, 2020, was for $30,372. This amount was significantly different from the one that the plaintiff had expected to send on the project, which was $7,320. So if you went from $7,000 to $30,000.
But go back to 4. He told her he doesn't know what that $7,000 estimate was for and that he was using a new invoicing company. He says, I'm still trying to figure out what the 7,000 is for. And then she says, do I need to estimate? So he admits up front that $7,000 didn't look right. We still got no info what that 7,000 is for.
Okay. All right. I see what's going on here. Okay. Yeah, because that does say December 16th right there. All right. So number 6.
Hold on. These are pictures, so I can't scroll down. So did you want to finish reading 5?
I did finish reading 5.
Oh, you did.
6.
Okay, that's weird. Hold on. I promise I can count. The plaintiff was forced to pay to board their horses at other facilities due to the defendants not even beginning construction by the date that the 3 horses arrived. This cost an unexpected additional $2,621.67 at blank in Thermal, California from February 1st through March 1st. See Exhibit 7.
Which is a bunch of gibberish, by the way. I don't
And
even know what it's saying.
$659.20 from February 1st through March 10th at Lauren's blank property. See Exhibit 8. That was weird. That looked like a QuickBooks. Exhibit 7 looked like a QuickBooks thing. Exhibit 8.
Except it looks like alien handwriting or something. Like it doesn't even, I don't even understand like what's happening here. So
Yeah,
I find that interesting.
That's weird.
All right, so let's see, that's Exhibit 8. Okay, so 7. The plaintiff reached out daily to the defendant to ask when construction would begin and to emphasize the need for the facility to be completed. See Exhibits 9 through 30. What? Oh, yeah. Okay, so we got some text messages to read. We're going to read these first, okay? I got these because I can make them bigger. All right, so these are all just her. I'm not responding back to her at all.
And I'm like, where's the response gray boxes?
Oh, gosh. So these start January 21st. Question, I want to call them Monday, January 25th. Hi, please let me know ASAP how I can contact the financing company you use so we can get started. Hi, the lady who does my footing additive was going to call you today. Links her number. Here's her info. Thursday, could you call her back, please? I have to order the additive from them ASAP. Sunday, January 31st. Hey, we can get going on building now. Need to get financing sorted out, so please let me know ASAP. February 3rd. Hey, need to know today whether you are doing this or not. February 4th. Hey, what's the update? She does not take a fucking hint. Let me tell you what. Oh my gosh, so annoying. February 5th. Aren't we supposed to start Tuesday? Hey, I didn't get anything yet. February 8th. Still haven't gotten anything. Monday, February 8th. They have tried to contact you multiple times, and so have I on other occasions, and I think I need to go with someone else who is more reliable and reachable with cute pictures of horses. It's the only thing getting me through this. Well, don't worry. There's more conversations of just her by herself. If this is even, oh my God. Yeah. If these are even actually texts to Sean. Because how does he not answer for a whole fucking month and a half?
Right. And it says 9 through 30. Does she have 30 of those?
Mm-hmm. Yep. Sure does. All right. So she continues then to February 10th. Let me know what you want me to do with financing. We want to make it easy for you. February 11th. Hey, sorry to bug you. Any update? Still on for Monday? If so, I need to make sure I book my flight for Sunday. February 12th. Think we are independently financing, so that should be way easier on you. I'm around if you're still free. What's your email so I can send you everything? February 17th, any update on the start date? And he says, I'll call right back. Oh, okay.
So he's calling. She texts, he calls back.
I see. Yes. Okay. Okay. So I guess maybe those are texts to a real person.
Because there's some people who pick up the phone and use the phone as a phone. Llama.
I know. I know, right? So then Thursday the 18th, hey, I really need to figure this out. Then he sends her this alien language thing that I don't even understand what it is.
I can't.
So that's weird. It's all alien gibberish. Don't worry.
Okay.
And then Tuesday, February 23rd, are we doing this? Please. And a question mark in case you didn't know. Hey, what time and where to meet? Another question mark. Thursday, February 25th. The structure is getting taken out tonight and everything has been ordered. So are we good to go? I have my 3 horses coming Monday night. Then what's the address? And here we go. Here's some more. I didn't get anything yet. Friday the 26th. Still nothing. I have horses coming Tuesday. Friday the 26th. ... Ooh, she's not happy. He says, sorry we had trouble today. I've been calling everybody and their cat and drove to Tucson after I left Glendale. All pipe is completely gone at the moment, and we have enough at yard that will not meet structural specifications as far as load carrying posts. We have all beams, red purlins, and PBR tied down. We are now lacking 2 3/8 of an inch and 3.5 inch at the moment, but we have every reputable supplier looking right now. And we also are trying to get a truck in from North Dakota. It has been very stressful and disappointing today, finding that our material that was supposed to be set aside at one supplier wasn't completely there. Ooh, that's crazy.
That's frustrating.
It's a Libra thing. No, yeah, we don't do phone calls here. No, thank you. He sends her a screenshot about the number 2 left, all but not the number 1 I was getting either. Probably in between those qualities at $44. Any luck on more pipe? Thanks and good evening, sir. Then he says, hang in there. We will get this figured out hopefully by tomorrow. She gets a thumbs up. Now I'm even trying to black market. LOL. All right. So dude's trying to get whatever bullshit she asked for. Like, is this stuff she asked for like hard to come by in general? Or was she specifically wanting,
It's January, and if it's not at the yard and snowstorms, weather's preventing trucks from coming in or something, I don't know.
Could be. Well, I guess also it is 2021. So I guess, yeah, COVID times could have been hard to actually, get things. So then she messages him again on the 27th. What's the update? Really need to know. Sorry. And then Sunday, February 20th. Sorry to text on a Sunday, but I've got people waiting on me with these horses and I need to make a plan. What's the status? March 1, please give me a call with an update. 3 arrive tomorrow. Why are your horses even arriving? Like,
yeah, why would you not plan better?
Right? That's what I'm saying. Please. Oh, I already said that. Hi, this is March 1st. Hi, had to end up boarding them since I couldn't get the stalls done. Please call me whenever you can. I'm really getting nervous about the project getting done, and I'm concerned since we don't have a contract yet. What? You don't have a contract yet? What, you okay, Kina?
What? Then why would this person be ordering any supplies if you don't have a contract?
Right? I thought she said they had a contract since December.
That's what I thought too.
Interesting. March 2nd, tractor's coming tomorrow. ? Please call ASAP. I have stuff arriving tomorrow and really need to know what time you guys are starting today. Wednesday, March 3rd. My dad just shattered his knee. I need surgery later today. We're having a very rough day, and this is something that we really need to take care of so that we don't have to worry about this, where our horses and things are going. Can you please give us an update? Drama. And then she sends a thing about moving bales. March 3rd, I hope you guys are safe. Did you talk to your wife about the contract? March 4th, checking in on the contract and if equipment comes today. Interesting. Okay. God, she texts so much. Ugh.
Her thumbs have got to hurt. Oh, yes.
Right. Oh, gosh. Please confirm that someone will be there between 2 and 6 tomorrow, Thursday, March 4th. Explanation points for whatever, I don't know. March 4th. You're killing me here. Need confirmation ASAP. I've got 6,500 pounds of footing coming tomorrow between 2 and 6, and they won't hold it. They will know the time in the morning, but here's what the lady said. A bunch of numbers.
On skids, yeah.
Friday, March 5th, they are actually backed up on shipments and asked if they could deliver on Monday between 4 to 6 p.m. Thought that was better. Let me know when you are coming by to do the contract today.
This is March,
This is March
but
5th.
you
Yeah.
said she had a contract in December. Okay.
Yeah.
I'm trying to do months instead of math.
Just spoke to the horse mat driver, and they said they are delivering first thing on Tuesday. It's a lady driver who needs to make sure that she will have 2 guys to unload them. If you've ever seen the show Trial and Error, they do lady driver with red flags. It's so funny. Anyway, I figured that was fine since you guys will be there, but please let me know. Friday the 5th, is that okay? What time are you coming with the contract? I'm waiting here at home. Gosh, guys. Like, I'm sorry. At this point, a reasonable person, I think, would be like, you know what?
I would have
No.
tapped out and said no contract, no communication at this point.
Right?
But that's just me.
Then on the 6th, she says, hi, I stayed home until 6 yesterday, waiting for you to come with this contract. Sad face. When are we doing this? Please confirm that you guys are starting tomorrow and will be there for the footing delivery. The shipping company called again, and I need to confirm. March 8th. Hello, are you guys starting today? And then he sends a picture with half of his fingertip cut off. So
Okay.
I'm going to go with his answer.
I need you to make that bigger. No, I'm kidding.
I can't really make it bigger.
Kidding.
You love damn Montana. You love Trial and Error too. Me too. And side note, we're going on a side quest real quick. On Peacock, there's a new show called Stumbled, which is about like cheerleaders in, I think, Oklahoma, Texas area, right? I'm pretty sure it's done by the same people who did Trial and Error. So if you like that, go watch Stumbled on Peacock. They have 10 episodes out. I think it's delightful. Not enough people watch Trial and Error, and I loved it. Loved it. So that's just my sharing. Sharing is caring. I'm always trying to get people to watch TV.
His finger. Part of his finger's missing. That's not good.
Right. But right. So then March 8th, just got a call from the lady who is bringing my mats from Canada. She will be here first thing tomorrow. Please let me know if you're going to be here for today and tomorrow's deliveries. Can you put up something temporary for my horses for tomorrow, Wednesday, because the lady can't keep them longer? When are the equipment guys coming and you with the contract? Can you please confirm timing? I have both footing and mats coming first thing. What time will you guys be here? Something with the equipment. I don't know. Then he finally responds, we'll call right back. We are having a meeting with insurance adjusters. Thumbs up. The lady will be here soon. Are they on their way? Urgent. I'm going to be screwed if no one is here. Then she says, coming soon. The lady is waiting and asks for an update. Any update? She needs an update. She is late for her San Diego delivery. Is it like, do they really have to? Is that their responsibility though?
That's what I'm sitting here going, why is it his responsibility? You don't have a contract. You should have horse hands, ranch hands, or helpers there to do that.
Right?
I
know. I don't get it.
I don't get it. But
this is where she finally learned to switch her phone to dark mode, which I'm thankful for. So she says, can you guys please help me flatten this into ever bedding? I'm getting nowhere fast with me and a shovel. Like she can even lift a shovel of stuff probably. Oh, I forgot. She's done 1,000 boot camp classes. So she is freaking tough as shit. Wednesday, March 10th. What time will the stalls be ready? The horses arrive at 4. Can you guys take down the shade? Hey, you guys are still coming today, right? My horses are going to lose it being cooped up for a long time, and I can't get the water to work over there. So hoping we get going. Why are you bringing your horses?
if it's not ready.
Right? Why are you doing that to your horses? I'm just saying.
Yeah.
I wouldn't do that.
Because I would think there's plenty of places that she could go and rent stalls to put them in.
Yeah, I would think so. Then she says, just checking in on the project. Plan for today. Getting nervous about the project status. Hey, what time are you coming? This is March 13th, by the way. Just wondered if you have any idea when you're coming. Want to make sure I'm home in time. Question mark. She also says, woke up to one horse all cut up from the cinder block stalled. Okay. Oh, and then that's the same arena clean coming tomorrow. And last but not least, 30. Oh, this was the rest of that one. Woke up to one horse all cut up from the cinder block stall. Please let me know when you are starting this. I don't want them in these stalls much longer. Are you coming today? And this is March 15th. He says, on our way. She says, thanks. Then I'm back. March 15th. My mom says there are 2 tanks, one in the arena where the shavings are, and she is finding out where the other is. And then we'll get to Exhibit 11 in just a second. So those are her conversations. I don't know why they stuck with this guy, to be quite honest with you. If this is what's going on, it's crazy to me.
Yeah.
You're dealing with living things, I guess is my,
Yeah, I'm like,
And this whole contract, where's the contract? What? Okay.
but I thought her legal filing said they did a contract in December.
That's what she said. Time is irrelevant.
I'm wondering
Laura.
if she signed the contract and she's just waiting on her copy of the executed is what I'm wondering. Because I doubt he carries around a copier to be able to Xerox it and give her a copy. He may have said, let me copy this and get it back to you is kind of what I'm wondering.
Could be. Now, back to the filing. She goes on to say the defendant was extremely difficult to connect with. Most of the calls and text messages made by the plaintiff went unanswered because he has this thing, Laura. I don't know if you've heard of it. It's called a job. So people aren't just available all the time because they're not just, hanging out on the internet in their casitas. So just saying. When the defendant did answer the plaintiff was given excuses and told the work would begin in the next day or two. The plaintiff felt that the defendant was the right person for the job and was patient with his timeline, but did request updates. On February 8th, the plaintiff told the defendant that they needed to hire someone else who was more reliable and reachable. See, we're now on Exhibit 11. But the defendant called the plaintiff and assured her that he would complete the work soon. So February 8th, she says, well, we read this earlier, but we'll read it again. They've tried to contact you multiple times, and so have I on other occasions, and I think I need to go with someone else who is more reliable and reachable. So at this point, though, this is your own fault.
This is your own damn fault.
Honestly. Like, even if she's saying everything is true and he is being dodgy, which I do, find that a little hard to believe. I mean, not hard to believe because it happens all the time.
It does.
But she kind of is making it seem like he just ghosts her all the time. And I don't think that's entirely accurate. But anyway, so the plaintiff also asked repeatedly to review the contract that the defendant said the plaintiff would need to sign. The defendant would answer that he had forgotten to send it over to review, but that he would do it as soon as he got home that day. Okay. All right. You want to do point 8? What time do you have to leave? I forget. Do you leave?
I have to leave at 30 after, so at 1:30.
Oh, okay. So yeah.
After the defendant's crew arrived and unloaded their heavy machinery, the defendant asked the plaintiff to sign the contract. The defendant told the plaintiff that the contract is standard and that she did not need to review it.
Okay.
The defendant pressured the plaintiff to sign it immediately because he claimed he was needed immediately for an issue with this crew.
This must be the signing under duress that they claimed. Oh, okay, of course, because that's what that means.
The plaintiff signed the contract and was told by the defendant that he would email her a copy of it as soon as he got home. He never did. But Between the time that the plaintiff signed the contract until today, the plaintiff had asked the defendant countless times for the contract, but he will not produce it. The plaintiff paid the defendant $17,719 on March 17th. See Exhibit 31 to begin the work.
So there's a check for $16,000, I guess.
Okay.
So.
Okay. And then on March 17th, or the plaintiff paid
Hold on just a second. If I should have made things bigger, but I didn't want to spend all of my time making this. But this check that's there, all right, it says total $34,000. They've already paid $7,710, and their balance due was $16,789. So it kind of seems like they've known about this for a long time. How much?
Okay, but the math isn't mathing.
Mm-hmm.
Okay.
Mm-hmm.
The plaintiff paid the defendant $8,883 on April 6th. See Exhibits 32 and 33.
Yeah, so here's the invoice for that. Here's all of the things that they were totaling. So they apparently did pay them some money, but also that's kind of their own damn fault at this point.
But I don't know.
All right, so the final payment of $7,906 was given to the defendant by the plaintiff on April 23rd. Because defendant assured plaintiff that the project would be completed by the end of the day. Here's their emails. Again, this is the info. Oh, whoops, wrong way. Oops. Their invoice and their total remaining balance was $7,906. They said the mat installation be completed. Demo was complete last week. And so stuff has been going on during this period of time. So, okay. All right. The payment instructions said remaining 50% due at completion of estimated scope of work. The job was by no means completed that day, and the defendant completed very little of the remaining work by the beginning of June. Yeah.
Okay. Number 10, it should be noted that the defendant did not change the sign date on any of his invoices, so they will all appear to be signed on March 16th, even though the defendant's prices rose significantly from the beginning to the end of his time working with the plaintiff.
Okay. The defendant raised the price gradually but drastically during the course of construction, despite the fact that the scope of work completed was significantly less than what was quoted in the defendant's initial estimate of $7,320. See Exhibit 3. Okay, I guess to view your estimate for $7,300, click here. That's your estimate. That's not an actual
that's your
number.
estimate.
That's not saying it's an estimate. I don't know if she knows what that word means. The final amount paid by the plaintiff to the defendant for non-completed work was $34,508.
Okay, but you know what? If you go back to that estimate, if you remember the text, he said he did not know what that was, and that is dated December 16th. He said he didn't know what that was.
Nope. It looks like it could even just be a rando generator sort of thing, right? Like you do that. Sure, Jan. Right. Oh, there's elbow feet. Hi, elbow feet. Hello. So the defendant was paid by cashier's check or credit card. See Exhibit 35. No, 37. There we go. The defendant was paid by cashier's check or credit card. Oh, that's this one. My apologies there. Each time he requested a payment from the plaintiff. So he says, got the fans, because this one's kind of hard to read too, over the vehicle, some pictures, all the cab in the bed. And she says, OMG, couldn't fit in my little SUV. Is that what she calls her vagina? Probably. Then she says on 4/6, did the electrician come? I forgot there's another electrician who wanted to quote me who is almost there. I forgot to cancel him, just so you know. Forgot to ask if you guys can hang the fans in the stalls that already have electricity. And did you put in misters there so they can have those? And he says, okay, I just got in front of my computer. I think she sent an address or something. And he says, receipt sent and deleted information. Have a great dinner, and we will see you tomorrow.
She sent her credit card number.
Ah,
I bet
yes,
you.
that makes sense. That does make sense there. Okay. All right.
Okay, now we're on more. While on the stable comfort mats installed by the defendant, the plaintiff's pony, Tiffany, contracted, excuse me, laminitis. The stable comfort mats are designed to prevent foot problems like laminitis, which is why they were purchased by the plaintiff. This resulted in a $1,805 vet bill on April 20th. See Exhibit 38.
I mean, but also, how, again, is this not her fault? In a sense that, like, you knew that this was not a habitable place for the welfare of these animals, that they could potentially, like, I'm just saying.
Yeah.
These are living things we're talking about. And as an owner, I would think I wouldn't want to
This is way in September. Hopefully they finished the work by September.
Oh,
And
good call.
they were actually walking around on it. So something might not have been right.
I just, coffin joint. Also, could this also have just been a random, like, vet? I don't know how horses work. Like a regular vet bill or something. Like, I don't know.
I don't know.
But also, if an area wasn't good enough for things that apparently bring you in $10,000s of dollars, possibly million, why would you put them in this kind of environment if it's not ready to go and could potentially harm your money maker horses? Doesn't make any sense to me, but okay.
Yeah. I don't know.
Hmm.
This started to raise red flags to the plaintiff about the defendant's work. Finally.
Oh, hold up. Kimbo coming in hot over here. I viewed the vet receipt. It was for treatment of joint injections that aren't for treating laminitis. See, that's what I was wondering. Thank you. Thank you, Kimbo, for that information. That's what I was wondering.
I can't see it.
Oh, well, I'm sorry.
Oh, sure is. It says right there, prostrate injection left coffin joint. Yep.
Yeah, I don't know.
Okay. Thank you. The plaintiff's prize hunter jumper show horse, Sicarico, however you say that.
Sirocco, that's what I call him.
I see Sicario when I see that spelled like that. Sirocco 91 has been seen by vets for lameness issues that they attribute to the unevenness in the stable comfort mats installed by the defendant.
Lameness issues. I don't even know what that means, but I love it. Sorry, my horse is lame. It's suffering from lameness.
With one of the treatments being steroid injections to his back and legs. See Exhibit 39.
Oh, that's this one still.
Okay. Sirocco 91 was named the best equitation horse at the United States Equestrian Team Talent Search Finds. This is the most prestigious title. Let me open up the next one. An equitation horse can win, and horses of this caliber have sold for as high as $1 million.
So I know when I have something worth $1 million, potentially, I put it in a shitty little.
I wouldn't be hiring the person off Facebook. Just saying.
Right? Like, what? Okay. We're supposed to take you seriously. Okay. Now, on or around May 18th, it was determined that the instructions for installation of the stable comfort mats had not been followed and that the mats were dangerous as installed. The plaintiff researched installation online, which then makes her an expert, and learned that there should not be a single ridge in one mat, let alone 15 in a single stall. The mats were sinking into the ground. The material in the mats was leaking and were truly dangerous as see these exhibits, which I don't know what I'm supposed to be seeing here, to be quite honest with y'all. So you probably know better than I do, horse people, but
I never look underneath what they're walking on. We've got Kimbo, who's got some great information. Maybe she can help us out.
Lane means they had physical issues that affect mobility. Oh, okay. All right. Back and hock injections have zero to do with laminitis. That is maintenance of her show horse. I knew it. They're such scammers. The defendant had even posted photos of the incorrect installation on his Facebook page as if he were proud of the work. How fucking dare he? Oh my goodness. I mean, this doesn't look... Is this where, like, the little areas here? Is that where they keep the horses? Is that where the horses live? In these, like, tiny little...
I mean, I'm hoping they're living in a barn and they only bring them out there during the day to groom them, water them, saddle them, take them for walks. I don't know. That's different. That's a different kind of horse thing than I'm used to.
Interesting. Okay. Defendant reached out to a Mr. Jason, one of a limited number of stable comfort dealers in North America. Upon seeing defendant's work, he stated that it was the worst installation he had seen in 20 years. The plaintiffs had to immediately move their horses so that the defendant could attempt to reinstall them, which came at a cost of $1,112.90. Okay. Well, I don't know why you needed somebody else to tell you that it was bad. They've been doing this for years.
That's what I thought. I mean, I'm like, shouldn't they know? And I will read this last one before I have to jet, and then I will be listening to you guys.
Okay.
Defendant was given a second chance to install the mats by the plaintiff. See exhibits 46 through 48.
Oh. This is just she... Oh, that's the wrong way.
Did she download the instructions?
Yes, that's exactly what she did. It looks like this is all the steps of how to do that. And then she says, I'm attaching photos. I am very upset and disappointed as I trusted and paid you to do this correctly. And this has put my horses in extreme danger in a monsoon situation or in any situation should the ground give under their weight. This needs to be addressed and work needs to be started today to fix it. Please let me know if I need to make arrangements to move the horses off the property if needed while you lay the foundation, as I will not keep them in those stalls longer and put them at further risk of injury. You should just move them. Why are you waiting for him to tell you?
Okay.
Honestly.
Kimbo, that is what I thought. And I thought, okay, they must be using these mats for something different. I thought it was just to keep it cleaner and give them a little bit of cushion, like putting a mat in front of your kitchen sink to stand on just for a little more. That's why I was like, maybe there's something way more going on with these special horses than normal horses.
They're just mats, just regular old mats?
Yeah, that's why I was like, yeah.
What?
Okay. Glad to know I'm not totally crazy.
Guess not. You have told me repeatedly over the course of this project that you will be here to meet with me or the crew will be coming shortly, and no one shows up. My time is valuable, I'm sure. And I am no longer accepting excuses for why this project has taken months and why what has been done is questionably structurally sound. There are many other concerns about the project that also need to be discussed. But the barn and the immediate safety of the horses needs to come first. I don't want to escalate this, but I will if this is not addressed and the project completed this week. Okay.
Okay. Defendant refused to oversee the work and did not communicate with Mr. Blank as directed by the plaintiffs to ensure proper installation. Two of the defendant's young workers who had no experience with stable comfort mattresses rushed through their installation, which was again deemed to be wrong by Mr. Blank. See Exhibit 50.
Okay. Hi, could you please check in with Sean before he proceeds further? In a meeting right now. Sorry to miss your call. Can you give Sean a ring? Just left him a message. He's went too far again. To whomever that's supposed to be, Mr. Mystery Man. Kimbo, yeah, right? Says, first of all, when doing construction, you don't want horses near it.
Yes.
Nails and screws, if stepped on, can ruin a horse, let alone breathing, like
And the noise,
inhaling.
they'll scare them. It could make them anxious. I mean,
Okay. So I just thought I just didn't know shit about horses. Okay. I was like, maybe I don't know what I'm talking about. But no, it turns out everybody knows this except for Laura. So, okay. I'm glad to see. Her time is worth nothing.
I am sad that I have to leave, but I am going to put in my earbuds and listen while I'm driving.
Okay.
Enjoy the craziness without me, but I will see you back tonight.
That's right. Tonight, True Crime and Wine Time, 8 p.m. Eastern, and we are covering Cassie Jo Stoddard's case. So I will see you then.
Thank you guys for letting me hang out.
Yes, thank you for joining me today.
Bye, guys.
We'll talk about more horse stuff.
Yes.
All right. Bye, Terry. Thank you so
Bye.
much. Bye. All right. Let me see. Maybe this one's better. Oh, no, that's not better. Let me see when it's just me on here. Nope. Ugh. That's not helpful. Try to make it so you guys can see things better, but I'll have to work on this some other time. Isn't this would be 2021. Is that when Greg starts up? Yeah. Right? Greg comes into the picture. So she's very busy, obviously, because she's also representing herself in that. So come on, guys, think of her time. I think the foundation or floor under the mats has to be level, and that was the issue, but I could be wrong. But they're also horses run in the wild and shit on uneven ground. So I don't know. Keep in mind their entire property is 1 acre. That's house, casita, barn, and riding area. These horses had nowhere to go. Should have boarded them out. Are you kidding me? What? That's all the land that they have. 1 acre and all this shit's on there? Shut up. Just because Uncle Joe charges $700 an hour. How is she having that many horses on 1 acre? Oh my gosh. That can't be legal, right? That seems crazy to allow that for these beast-sized animals, wow. The plot thickens. I know, right? Always something around the corner with this one. All right. So according to the defendant, the quick feed feeder boxes were more difficult to install than he originally thought, and battery boxes would need to be fabricated, which was not done. The delay to install was drawn out for weeks. Finally, plaintiffs had to hire a handyman for $419, and the correct boxes were purchased on Amazon for $12 each. Well, look at that. You solved your own problems. Congratulations. No, that's not very much room for 1 horse, let alone several. Exactly, Pam. What? Uneven stalls does not render a horse lame. Give me a break. You know who's lame? Laura. Laura has been diagnosed with lameness. Yeah, I feel like if that's not illegal, I feel like it should be. That's probably why they can't run a commercial business out of their property. Do they also live in an HOA area too? Or because they'll be like, you can't run anything. If they did, I can't imagine them letting horses be on there. Wow. Laura's stall is definitely uneven. Yes. All right. So it was later discovered that the defendant's improper storage of these products during construction rendered the feeders damaged and unusable. The plaintiffs paid $1,733.96 for these items and did not get to use them once. This is 53, but that's 50. Oh, for some reason I don't have 53 on here. I must have missed one. Oh, well. Defendant was asked repeatedly to contact the president of the Nolan Engineering Company, John, for instructions to install the quick feeders. Defendant never contacted him. Okay. It was later discovered that defendant had no experience with the specialized high-quality items and had grossly misrepresented his skill set and expertise. Is it high quality? Because to me, it sounds like all the stuff is shit. So I'm just saying. The repeated delays and then, like, how do things get ruined that would also be out in the elements in the future? Like, I don't understand how that works. I don't build things, so I'm not, I'm not a carpenter or anything like that, or builder. The repeated delays and the negligent installation of the footing and the additives caused the plaintiff's horses to lose fitness due to their inability to work in an arena. Maybe because now I find out you have them on 1 acre of property. Maybe that is definitely on you at this point. I mean, I can't imagine that she's allowed to, like, take the horses out in the neighborhood and walk them on the street like a dog, right? I'm pretty sure that's not probably allowed. That's crazy. Plaintiffs could not advertise a horse for sale at their residence due to there being no area to ride. Plaintiffs has sold horses for as high as $150,000, such as Editor's Note, who won at the United States Equestrian Federation Pony Finals. Ma'am, you just said that was Pony Finals, and you said you sold a horse, and horses and ponies are not the same. Maybe they are the same in this context. I don't know, but I'm just saying, just to let you know, I have horse knowledge, and they are not the same. I wonder if Laura thinks she lives in some Lifetime movie. I do think so. I mean, she certainly has main character syndrome all of the time. Oh my gosh. Yes, if you want to build a high-end equestrian barn, hire an experienced barn builder. I mean, if these horses are worth so much money, why wouldn't you invest money so you could get more money for your horses like normal business people do? Oh, probably because they weren't really selling them. Dogs in my neighborhood are going crazy right now. Some are like howling. Do you guys ever do you have neighborhoods, dogs? Sometimes they'll all start going off and it like freaks me out because, sometimes animals know what's happening before it happens, like volcanoes and earthquakes and shit. And so sometimes it doesn't happen often, but all the dogs will start barking and howling. And I'll be like, oh my God, is this the time? Is this when the super volcano is about to go off in Colorado while I live in Ohio? Fun stuff. All right. So the defendant's construction delays occurred during the prime season for horse sales due to the months-long Arizona and Palm Springs winter circuits. And the plaintiffs had planned on making somewhere in the low 6 figures during this time period. Sure. The plaintiffs did not have a chance to make any money on their horses during the late winter, spring, and early summer seasons. Their time dealing with the defendant. Oh, so it's his fault. Why would that matter? I don't understand. Wouldn't you be taking them somewhere else to sell? Or can't you take a horse to like ride them? Does she take care of these horses every day? Because how many did you say she has? Like 7 horses now? I imagine caring for horses daily is a lot of work. So, right? If you don't like the contractor, fire him and get another, especially when 6 figures is on the line, allegedly. Right? I don't know. To me, making hundreds of thousands of dollars to even have that opportunity, I think I would be doing everything I can to make sure that opportunity just doesn't, go away, because that's a fuck ton of money to most of us. But I somehow don't think Laura has ever scooped horse poop. Probably not. I would say that they probably pay somebody to do that, but they're not really big on doing that now, are they? All right, so the True Text footing bags did not get opened by defendant until April 27th, long after the expected date of project completion. The installation instructions were not followed, and the wrong equipment was used to install it. This resulted in the footing being unusable and all writing being suspended until it was fixed. In an email exchange between the plaintiff and mystery person, a senior customer service representative with TrueText, Ms. Blank said, "I'm so sorry you've had to deal with product loss with your previous contractor, and I am so sorry your prior contractor did not offer you the proper services and support." Girl, that is just, you did not think that they were genuinely gave a shit, right? Like, that's just proper corporate talk there. But sure. Okay. Wait, exhibit 54. Where are we at? That's 51. Oh, here's one of the 54 exhibits that literally is nothing but a black bar. So that's cool. The True Text footing was purchased by the plaintiff for $6,878. See exhibit 55, which is, what's the date on that? The date on that was February 25th. So she orders all of this February 25th, and they hadn't even started work on any of this. So, oh my gosh, $1,300 for shipping. Oh, wow. That's crazy. Why does she insist on being so repetitive? I don't know. Because she loves talking. Kimbo says if she hadn't burned all her horse friend bridges, she could have used their facilities. Ooh, I don't know much about the horse world, but I might have to go down a horse world rabbit hole and get caught up with all the horse drama. Yes, Terry, we didn't know this. 1 acre. You have 3 goats on 1 acre. Yeah. Horses? 7 horses? It's like her medical records. She self-reported problems with the contractor. Yeah, she's just a real piece of work. It was discovered that the defendant's mixture of the True Text fiber footing, sand, and arena clean were so poor that it is considered dangerous. Arena Clean's technical support team told the plaintiff in an email that the photos sent to them by the plaintiff that the ratio of the products in the arena was incorrect and that there was a high percentage of fiber compared to the sand and arena clean. This means that there will be significant amounts of extremely fine, extremely light dust, which once airborne, due to its lightness, remain airborne for long periods of time. The dust is so fine that it is below the 10 micron and 2.5 micron threshold. The WHO has, not the band, the World Health Organization, has their maximum health warning on dust particles in these 2 regions. Oh, so now we're concerned. We're concerned with the dust particles with this, but not with the construction going around horses just being there. That's fine. That's fine. Okay. All right. It says, I don't know if she ever had friends in any world other than claiming her sister's friends with hers. I don't think she had any friends either. She's affectionately known as a barn hopper. Ooh. That means she causes too much trouble and gets kicked out with regularity. You don't say. You don't say. Can she go anywhere without causing problems and being the problem? Probably not. Right. So she shouldn't have had her horses there that whole freaking time. Cool. That's why in a desert climate, especially, you wet down the riding arena. She's so dumb. But what about the monsoons, though, Kimbo? What about the monsoons? I'm just kidding. All right. So, in addition, defendant was asked via numerous written communications when the extremely strong canvas backing that he ordered was going to be installed. By the way, extremely strong was in quotations. This is these text messages. So let's read these. I'm probably not going to get through all of this today. I'll probably be here for like another 15 minutes or so. I don't know. We'll see. We'll see. All right. Oh, no, wait, because I got to do Llama Learns after tomorrow. So, I don't know. All right. So these are from May 4th. All right. He lists the material costs. Should be putting in about 10 to 15 minutes. Should be pulling in about 10 to 15 minutes. She says, I see the material, but nothing going on. I'm frustrated because there is still so much to be done, and I made the final payment nearly 2 weeks ago. It is nowhere near set up with the arena, feeders, gate, canvas, Del Mar, and it is seriously impacting my horse and, Federal Lady, if you're listening, my business. I need to know when this is actually going to get completed because it doesn't seem like this is a priority project. And then she says later, the next day, let's do gray for the landscape rock. I just want to make sure it won't hurt the horses if they get close. Then she says on the 6th, are you guys coming today? And he says, sorry, I'll call you in a few. Just tried some guys this morning. She says, what is the state of the canvas? My horses are boiling hot. Well, maybe you shouldn't have fucking moved them there when it wasn't good for them to be there yet. What is the stat? Oh, wait, I already read that. If you can't do it before Saturday, please let me know so that I can make other arrangements to get it done. You should have already done that. The 7th, when are the shades coming? You said everything was going to be done 2 weeks ago today, and that's why I paid that day. The project is nowhere near done, and I am really getting tired. I don't know. The one that we hired to oversee the installation, and there is no excuse for that given our conversation last week. Your crew was working in the dark until 10 p.m. last night in order to rush through the process. The city of Scottsdale does not allow construction work past 7 p.m. and we had a neighbor complain. So she's like, oh, I know that you're trying really hard to finish this project that I keep harassing you about 700 times a day, but you don't know the law, and the neighbors complained, and now you're in trouble. Let's see what over here real quick. Let's see. She's so dumb, like all the time and lame for unstable. She is dumb. Like, wow. Good afternoon, text packet. I can't imagine she would have room for a riding area, more like a merry-go-round, right? Or like, gosh, that's like the size of those little like pony riding things that they'll do at like county fairs or something like that, where the ponies are so sad. According to the interwebs, monsoon season in Scottsdale is June 15th to September 30th. Oh, the more you know. I love that. Llama loves learning about stuff. Today has been fun. It has. Let's see. She moved her horses to Arizona, which is routinely over 100 degrees. That's why they're hot, right? That's what I was thinking. Like, I mean, I know horses can live in those environments, but like, it sounds like you weren't prepared to move all your horses and then you want to blame everybody else for it. Even though, in my opinion, you're being a shitty horse owner. Okay. And I can't believe you still are allowed to have these horses, is all I'm saying. I don't know if there's laws against it, but I don't like it. Oh, yeah. All right. So the defendant repeatedly told the plaintiff today. Oh, wait. No, I'm sorry. I didn't finish. Did I finish reading these? Oh, I didn't. I'm sorry. On top of that, you have been unresponsive all day. We will take action this week if things continue as they are. We do not have an operational horse facility as of the moment and have 3 horses coming in tonight with 1 stall not being completed. The other 2 stalls are not done and there's no access to them. The arena is not usable and needs to be completed. The wash rack is unusable. The gate near the casita needs to be put in so that the golf cart can go in to drag the ring. Oh, they have a golf cart. The canvas is not in the stalls, and there is no ramp on stalls 4 and 5. So, of course, bring your horses. Our horses have had nowhere to be turned out or ridden, and then something dripping small amounts of water. Tuesday, May 11th, no one has come today. This is just really ridiculous. I paid for this to be done a couple of weeks ago because you said you would be done that day. And it's like, once I did, the work pretty much stopped. It's now too late for me to dispute the charge with my credit card company. I don't even have an arena gate, the canvas, the feeders up, the cross ties, a finished arena. The foundation for the stalls doesn't look safe. Misters aren't working in 1 stall. Sharp edges on Delmar that cut one of my horses pretty badly. And the Delmar hanging off of the last stall. He says we had to fabricate battery boxes today and brackets for solar panels for feeders. The amount of work the feeders, and we'll see what he says there. But like, again, why? Okay. And she says, oh, this was only supposed to be $7,000. All of that work, there's no way you reasonably thought that was just going to cost $7,000. Get the F out of here. I don't believe it. Let's see. Your goat. Yeah, that's true. Your goats have an AC in their goat house. I mean, and you live in Texas. So, I mean, these didn't even look like they were sheltered up at all, but okay. Monsoons are a heck of a thing when the groundwater won't suck. Oh, yeah. That and flash flooding. I mean, those are no jokes. This lawsuit reads like all of her and her mother's lawsuits. High maintenance, demanding, inflammatory, and everything is someone else's fault. I mean, listen, I can get being frustrated with contractors, okay? I've been frustrated with them before when it took them a whole month to replace my very small bathroom floor, which they didn't even do. But this is about living beings, okay? Living horses. And I'm sorry, she just should have known. This is all on her. Okay. I think so. Because I'll bet, she's reached out to all these horse people companies because, and they told her that this was all about job. Did you tell them? Did you tell all these horse companies how many horses you have on an acre? Which they don't even have the whole acre because you got a whole ass house and a casita on it as well. Probably a pool. I don't know what her house looks like. But what? It's crazy. The final payment was not supposed to be paid until the work was completed. I don't know. I don't even know anymore when she paid what. I don't even think she talked to half these people. I think she just made that shit up as well. Why does a lazy person that lives 5 feet from the barn need an automatic feeder? Well, they could be hungry at any time. I mean, gosh. Oh, gosh. Okay. This woman, she always is just infuriating. The defendant repeatedly told the plaintiff today each time, yet the day of installation never came. In a desperate attempt to keep the horses safe from the elements during monsoon season, the plaintiffs ordered a canvas backing on June 5th, which blew down and could have had caused immeasurable damage and or tragedy on June 16th. All right, but these conversations she's had about all this bullshit was in May, the beginning of May, a whole month before monsoon season. And you're just now ordering backing at the beginning of the season. But okay. You're emailing me the video of the house listing before they bought it. Oh, yes, please. Yes, please. Yeah, you can do Tara at tcwtmedia.com. That works too. That's fine. Why does she need a gate for a golf cart? I don't know. Oh, yeah, I'm sorry. We got exhibits. Here we go. Is this? I don't know what we're looking at and why it's wrong. Oh, look, there's a little horsey in the back. Shut up, you guys. Is this? Hold on. Can I zoom? I think I can. Does this make it fair for you guys? Yeah, it does a little bit. See that little horse right there? Is that what the horse is living in? Like they don't have an indoor, like that horse, that giant fucking horse just stays in that all day? Oh, on the channel it says Terry. Yeah, well, there is Terry, and then me, and then Amy. It's fine. Send it to whoever. I'll get it. Terry will forward it to me or something like that. No worries. Surely not. Right? They keep 7 horses just like that? Don't like it. Don't like it. Okay. All right. On May 30th, the day when defendant allegedly sprayed the arena clean, plaintiffs discovered that not all of it was used and that the remaining amount had been taken away on the defendant's trailer. Wasn't that the same stuff? She was like, he put it everywhere. Defendant had originally instructed the plaintiff to get enough for a 110-foot by 140-foot ring. Plaintiff's rings are 110 feet long and 80 feet at the very widest part, with most of it being around 50 feet to 60 feet. Plaintiff ended up with a dry ring when it should have been soaked, given how much extra product was purchased. The arena clean that was used was carelessly spread on the plaintiff's dividing wall, eucalyptus trees, stalls, and tack trunks, and there were hundreds of rocks in the ring left by the defendant, despite the fact that this was the last day that the crew showed up. All right, so the last day they showed up was when, May 30th? I thought you said they were there in June. No, everyone has the email. Thank you. Thank you for doing that, Texas. I really appreciate that. All right. So let's see. That's those. Okay. The arena was nowhere near completed and ready for use, as the defendant claimed. So, I don't know. I imagine probably all those rocks aren't great, but I don't really understand what arena clean even does. So, it was discovered by witnesses that several items were taken by defendant, including a drum of arena clean, which was approximately $508. The total price paid by the plaintiff for arena clean was $6,878.40. Is she buying this on her own separately from the $30,000 that was supposed to go to this guy? Or is this all included in that price? Oh, Exhibit 67. Boom. Receipt. Okay. That she paid. When was this? I don't see a date on it. Defendant was told many times that the horses were getting injured because of the poor quality of the welding that was done. Which, these are her examples of that. I'm not a welder. But also, the guy said they weren't very experienced in welding. So I don't, know what you expect. Also, I mean, can't horses just kind of fuck this shit up anyway? I mean, would this withstand horse running into or like whatever? It cleans the arena. Oh, okay. Okay. Didn't they have a small barn? I think those covered outdoor stalls are just turnout areas. I hope so. Texas says, okay, who said they had goats? That's Terry. Terry True Crime. She has 3 goats, 2 mini ones, the twins, and then Jasper, who I think is a regular size goat. I don't know. Oh, they're okay. So the horses are not living in those little things outside. Okay, well, that makes me feel a little bit better. That's a horse kick. I mean, can a metal fence withstand a horse kick? I don't know. Yeah, she sometimes will bring her goats on camera. She also has a goat cam set up, but I don't think we've watched it yet. Or maybe she hasn't set it up yet, but they're so cute. What's your goat Instagram? What's Jasper's Instagram that she posts pictures of the goats on if you have Instagram? Oh, Jasper is a Nigerian dwarf, so he's not even a full-size one. Okay. Those look like goat fins. I mean, I feel like they need to be really sturdy for a horse kick. But what do I know? The workers even admitted to being new to welding and that they were making many errors due to their inexperience. The original foreman of the project was subsequently fired. Plaintiffs was told by one of the defendant's crew members that a big reason for the foreman's termination was that he had made many mistakes on our property. These admitted errors resulted in one of plaintiff's horses getting his hoof caught in the fence. Okay, which would be here. Oh, shit. Well, I mean, listen, they told you they didn't know how to weld. So I don't know why you were expecting this to work out. Oh, yes, there it is. Jasper, the friendly goat, friendliest goat in the town. My entire place is 4x4 welded wire. Horses kick, bite, and fuck up everything. Right? I mean, I just don't feel like that looks like even what you would use for horses, but what do I know? These admitted errors, oh wait, I already said that. And 4 of the other horses suffered cuts that have scarred due to the wire not being filed down properly. Oh, poor little horses. It's sad. But also, I mean, I think they're fine. They just may not sell as well, but it's fine. You're not selling them anyway. Let's see. This is not only inhumane, but the blemishes are detrimental to show horses who are judged on the basis of their appearance. Gate latches were not securely attached and all have been either loose or come off completely. Well, again, why didn't you pay money for a good-ass welder? I don't understand. Those scratches could be from anything, probably. I mean, I don't see why not. But, she is. All right. So defendant cut a large section of fencing out where the cross tie was to be installed, causing the plaintiff's most valuable horse to escape through the area where the fencing had once been and to become stuck in a very small gap between plaintiff's arena fence and their neighbor's wall. This could have caused the horse major injury, if not death, due to the defendant's negligence and incompetence. Well, plaintiff requested on several occasions that the defendant cease verbal conversations and instead communicate via text or email so that there would be a paper trail of communication. Okay. Though I don't see a date of when this actually started, but let's see what she has to say. How about that? She is cheap. I mean, they are cheap. I mean, they spend all their money at the House of Prime Rib. Gosh. That's why you don't put metal or wire at the bottom of stalls. Use strong, thick wood. Oh, that makes sense. Look at the age of that. Of what? What did I miss? Sorry. Let me... Are you talking about this clasp thing here that looks like rusty as shit? Is that what you're talking about? A correction due to the plaintiff's negligence. Yeah, I mean, I do feel like that's A lot of this is really on them. Right? That didn't look like a brand new latch or anything. So, all right. Oh yes, we were going to read these text messages. So she says, this is part of the beginning piece of the shade structure. So there is no way that your expense would not be that much different if you had to demo other large permanent structures. The shedrow, which you said was going to be 5-foot fencing. The shorter fencing is why my horses are biting and trying to mount each other right now. He says, I'm willing to work with, I just don't know what we are trying to get accomplished, as no one will call me, making it extremely difficult to communicate. Them never. What? No. Also, she then ignores what he says. Also, it needs something written about why the final stalls were built on such an incline. You have the receipts for what you paid for fencing, and I also have pricing from Bonanza from when you got fence showing an $18 difference for 4 feet and 5-foot fencing. He says, I'm trying to go through everything I have, which is all digital. If you have anything, please share to me. I will keep looking. It's really hard to accomplish anything through a text. Please give me a call. I want to get things in writing because a lot of our issues have been because we have spoken over the phone. Is that where your issues are? Is it? I don't think so. He says, can't we just document our phone conversation, right? Can't you just, I don't know, agree to press the record button, Laura? Just wondering. Oh, geez. All right. So there was that. The plaintiff then asked the defendant to shore up the hill by the first stall that had been created by the defendant. The defendant claimed to have built the barn on such an incline because that would prevent damage if there were to be heavy rainfall. But that was not the case. The barn flooded several times. Look at this flooding. I mean, yeah, it's not great, but I mean, I don't know if I would constitute that as flooding. I mean, maybe it is for the care of animals, but like that just looks like some rain puddles, but okay. The barn flooded several times and his leveling did not appear to have worked. Is this the barn? Because it looks like it's outside. I don't know. The plaintiff desperately contacted the defendant several times to fix the issue, but he did not respond. Right? Yeah, we're a one-party state as well, but I mean, they could have just agreed to record. I am so surprised. I mean, we all know why Laura didn't record a bunch of calls and shit. So that is what monsoons do. Yes. She must not know a lot about the weather. Let's see. Where was I? Okay. The hill was so high up that a retaining wall was required as the barn did not have a solid foundation otherwise. Look at that. Look at that, which I don't know what I'm looking at. The plaintiff was unaware that the defendant was not licensed to construct retaining walls according to the Register of Contracts, which, some more blank pages. I don't really know what this was supposed to be, but that's what she submitted. He was only licensed to do fencing, yet completed work for the plaintiff that went far beyond the scope of that. The plaintiff was also unaware that the defendant was not a licensed contractor while advertising to her and the public that he was in the fall of 2020. He did not get licensed by the ROC until February 12th, 2021. Well, he didn't even start work and there wasn't even a contract. So I don't know what to tell you here. If you have an open-sided barn, rain will get in and pool when you have it lined with rubber stall mats. Again, how dumb can you be? I mean, right? I don't understand. I don't understand this lady. The plaintiff text messaged and emailed the defendant with questions related to overbilling, double billing, and getting a refund. The defendant claimed several times that he was amenable to this, though I didn't see any evidence of that, but okay. Defendant was asked not to return on the property on June 17th, given that it had been 2 months since the plaintiff's final payment. It was clear there were billing issues, and the defendant had shown his inability to perform the work he had been hired for. However, on the morning of June 19th, defendant showed up at plaintiff's property at 6:50 a.m. Oh boy, the horror story. All right. Trigger warning, everybody. It's a horror story, a real life horror story. The defendant showed up at the plaintiff's property at 6:50 a.m. and entered the horse facility through their driveway. There were several workers on the grounds who asked what the defendant was doing, and he stated that he was looking for Laura on a 1-acre property. I'm sure she was hard to find. The workers instructed the defendant to leave the property, but they did not comply and instead left the horse facility to ring the doorbell of the plaintiff, Elizabeth Naylor's residence. Oh my goodness. More blank blocked out stuff. Defendant claimed he wanted to discuss the invoice with plaintiff in person, despite being told repeatedly to communicate only in writing. A police report for trespassing was filed with the Scottsdale Police Station. Oh my goodness. The drama. Oh my goodness. Right? Like, oh, I can't even believe she's living in Arizona, to be quite honest with you. She may be living in Arizona for a while. Oh, I bet those prisons are not great. 6:50. It's not even 7 in the morning. I can't wait till we get to the body camps. Right? All of this work for $30,000. Okay. But she says, well, the original was only $7,700. Bullshit. I know. The doorbell. The audacity. Maybe if you don't want people hitting the doorbell, I don't know. Don't have one. I don't know. My doorbell hasn't worked in 13 years, and I have no desire to ever make it work again. Oh, there's only one women's prison in AZ, which means if she goes, she will be with Jodi Arias. Maybe they'll be in the same block or something. Ooh. Interesting. It's called Estrella. Oh, interesting. Lori Vallow gave it 1 star. All right. So the plaintiff emailed the defendant right after his unwelcome visit that day and explained exactly what needed to be repaid. More blank stuff submitted. Cool. You know, the really important stuff, but sure, we'll just not do that. On June 21st, the plaintiff sent the defendant an album of images on iCloud to show him how dangerous and unacceptable his work was. In response, the defendant explained that he would pay back the full amount of money that the plaintiff had paid him, which was $33,447.57. There we go. More blank pages. And then this. Something overcharged for, so I am not going to write it out for you. The blank team can be honest and give them back. Says something about, will message you as soon as I cut it off. Hold on. Maybe I can. No, I'll message you as soon as I can tomorrow morning. I offered a portion that I had immediately and was denied. I didn't know what else to tell you. I find out indefinitely tomorrow. She says, this doesn't seem to be a priority to you. I don't know how you can live with yourself. Shut up. Shut up, Laura. Shut up. Okay. I don't know how you can live with yourself for lying and taking from my family when we trusted you. No, not another liar, Laura. I am thinking more and more about filing charges for what you guys took, but I'm going to trust that for once, you can do the right thing here and bring the stuff back to my driveway. He says, I agreed to pay agreed amount. I am waiting for the bank to issue funds that I'll know a set date tomorrow morning. As far as whatever, that's all she submitted. Oh my goodness. Oh my goodness. It was a calculated graft. Abso-freaking-lutely. Most of her evidence is blank. Right? Wallace. Hello, Wallace. Poor lone cactus guy. He got massively screwed and gets forgotten a lot in the story since his victimhood isn't as salacious. I think that it is. I mean, yes, it's not as like sexy as, faked ultrasounds and things like this, and we'll eventually see how this concludes, but I mean, this isn't some like corporate construction company. Like, this is just a poor guy with a team, as far as I understand, of his thing, like just a small business owner, I guess is what I'm saying. And it's disgusting. And I know they did it on purpose, because had they chose one of the more well-known ones who probably have their own lawyers, you can totally, take over for someone who just isn't that protected and skilled by millions of dollars, So who knows? It could be. Text Becca says, I'm surprised that she didn't offer to drop the lawsuit if he dated her. Maybe, or ask if they had a kid or something. No, they were probably too poor for her. Yeah, I could see why they didn't want to deal. Not just Lone Cactus, the other people. Like, oh my gosh, how exhausting this would be. So, but, feel free, Laura, to do whatever you want with us. I got lots of free time. And I know how the legal system works. So, just kidding. Don't do that. I mean, I'll deal with it, but don't be rude. On June 22nd, the defendant said that he did not have funds available to pay the plaintiff in full, but claimed that he had $16,723.78 available immediately, and that he had applied for a loan for the amount he was deficient. Again, a blank exhibit. Defendant claimed that he had a daughter who was recently diagnosed with thyroid cancer and was receiving radiation, and asked for an extension to pay until July 1st. Shut up. What? I mean, what? I don't know who this is supposed to be to, but he said he never mentioned having kids or any family being hospitalized, but talked about his wife and puppy. I think he lied. June 17th, he told you his daughter was hospitalized, and on June 21st, he told me he had been in Hawaii for 2 weeks. First of all, who are you even texting? All right. This was December 11th, 2021. Get the fuck out of here, Laura. When he didn't think of all my dad's illnesses and my depression and insomnia and all this other stuff that he should have taken into consideration. And you cold-hearted bitch, is like, meh. He claimed to have a daughter. Who would make up medical problems? Who would do that? Laura. Unbelievable. Oh my gosh. I'm sorry. That pisses me off. I mean, listen, everybody's family has shit going on. And yes, this is a business. I get that. But the fact that you started out way in the beginning of this whole thing with listing all of the ailments of your fucking dad, and then you're saying, oh, he's probably a liar about having a sick kid with cancer after all of the bullshit that you did or allegedly did, get the fuck out of here. Wow. I'm sorry. That makes me so mad. Because that's a child. Like, I think, can she get more of a disgusting excuse for a human being? Turns out, yes. Yes, she can. She just keeps doing it. Oh. Right, for a business that's not a business. Oh my gosh. Sorry for my rant. That just makes me so mad. Just to say is making it up. I mean, I don't know if he was or not, But like the audacity for her, guess what, Laura? Not many people are like you who make up shit. Anyhow, allegedly, the plaintiff is now aware that the defendant does not have a daughter with thyroid cancer and that he made this up to delay payment. Friends, is there proof of this? Is that true? Did he make it up? Surely not. Surely not, because then I don't know. The defendant had told another client who was dissatisfied with his work that he was unable to respond to her messages because he had been in Hawaii for 2 weeks. Okay, that's this exhibit here that I'm showing you. Well, in reality, the plaintiff was in Arizona as he had seen the plaintiff during the time period. Okay. So your friend that said he was in Hawaii was lying if he was there in Arizona and you saw him. So, okay. I don't know why you're saying that they're credible then. Never could find anything either way with the daughter. Oh. What a shitbag. The defendant claimed to have... Oh, wait. No, I'm sorry. That's not where I was. My apologies. Plaintiff gave defendant a deadline of 5 p.m. on June 25th to refund $33,447.57. However, no payment was received. The defendant claimed to have issues obtaining the loan initially, but said that he had been approved on June 25th. He was asked to have a third party bring the funds that he had available to the plaintiff immediately, but claimed it was too late in the day to do so. All right, let's see what these are. Okay, get over here so I can read them better. Guys. Okay. Calm down. Oh, that first one we've already read as earlier. Okay. That was 101. We already read that. Left bank today at 5. Loan was approved. I'm meeting with banker tomorrow morning at approximately 9:30 a.m. to find out when funds are to be available. We'll send you a message shortly after that. So this guy's allegedly trying, you can't just walk in and be like, hey, give me a loan now. Okay, great, thanks. For most people, for us peasants, that's usually not how it works. So then she says, I'm not waiting past the deadline tomorrow for funds to settle or any other delay. It has been excuse after excuse with you. Says again, Pat. You have lied to me more times than you've told me the truth, and I would be a fool to believe your story about the bank and when funds will be available. Would you though? My funds were not easily available when you illegally asked for them before work was completed, but I gave them to you, trusting that the work would be completed that day. As I said, I have surveillance from when you guys were here, and she cuts that off. He says, I got a message at 3:30. How was I supposed to drive from Casa Grande to Phoenix, go back to back, get a cashier's check, find a third party to deliver the check, and have it before 5? She goes, you knew this long before 3:30. Yeah, guys. Jeez. I can't take this. Oh, I'm sorry. This is him. Let me not be so snarky. He says, I can't take this anymore. All this needs to be done in one check on an agreement in writing of some kind. I have to see what a settlement agreement is on or before Thursday, 1 p.m., July 1st. She says, you can't take this anymore? Seriously? You committed multiple crimes here, agreed to an amount in writing, and you have the audacity to ask me to sign a non-disclosure agreement, which is typically used in the workplace. They happen all the fucking time, Laura. You offered to bring half of the money, and you have reneged on that and come you with your own whatever. Okay. Okay. She's something. The audacity. Pam says, with all these texts, I'm more convinced that the course submissions are all cut and paste. I know, right? It's amazing how she can lie to everybody, but they can't lie to her. So, liars only want honesty, obviously. Have you seen these texts with Lone Cactus before? I haven't. They're new to me. I mean, those were because her summary of judgment is like 3 parts. The reading is only 31 pages. Then there's like a butt ton. These are all the exhibits that are attached to that one in particular. But then there's 2 more, like 40 and 30 pages of exhibits. I haven't went through yet, so I'll go through them tonight before we continue it tomorrow. But that's where you can find them, is the summary of judgment, part 1. So she is so insufferable. Insufferable in the workplace. Oh my goodness. Okay. Where was I? Then he says, this is Friday, June 25th at 10:59 a.m., getting closer to the deadline. He says, good morning. I just finished having a long talk with loan manager, and he said funding will be available in 3 to 5 business days. Once I receive that day, I will make a cashier's check available in agreed amount I full and have it delivered to your residence if you agree to that. So a fair date with the information I've just given, end of day, Thursday of next week, the 1st, would be the latest it would be for you to receive payment in full. If agreed to, this is what was told to me, and I even asked if there was a way to expedite process, and they repeatedly informed me it was beyond their command and it's the process. I mean, yeah, for that much money, probably. Also, the July 1st, isn't that when she calls the cops to like report him for trespassing and stealing stuff? And that he was like on the property like a week ago? Yes, that's when she had enough. She called the police. All right. Defendant was advised that fees would continue to amount over the weekend and that plaintiff would investigate his work to determine if further charges would be incurred. Defendant failed to acknowledge this communication. Okay. This guy should have gotten a lawyer a long time ago, but they're expensive. So on June 28th, the plaintiff made another payment request with the additional fees and discovered damages now amounted to $44,441.43. Hold on. We got more exhibits. Wait, 106 to 109? Is that these? Oh, yes. This is all just like a breakdown. I'm not going to read all these, but that's basically what it is. A breakdown of all the different parts of stuff, which, to be paid by July 1st, 2021. Oh, so she does do that. But this is her breaking down the monies. So this new amount included the materials that the defendant said he needed and that the plaintiff had to pay out of pocket. That's right. She all of a sudden is like, I'm going to put all this shit on here. It should be noted that this does not include the replacement prices that the plaintiff will need to pay for new stable comfort mats, Arena Clean, Quick Feed, and True Text, which have gone up in price and now amount to more than $40,000. I don't understand why she needs to get all new stuff again. I mean, interesting. Defendant has ignored all of plaintiff's requests for updates with respect to payment, as well as demands to see the contract since July 1st. Multiple requests for defendant's insurance company's information were also unanswered. Well, I mean, legally, I don't think he has to give them to you. She says in these text messages, I have filed a very lengthy and detailed complaint with the Registrar of Contracts. You have until 6 p.m. to approve this payment, or this is going to litigation and will certainly cost you much more. What is the name of your insurance company? Okay. He says, I currently don't have $44,000 to pay at the moment. She says, you can do 2 payments. Look at her being generous. He said they would have to get spaced out and get our payments in writing, contract agreement of some sort. Did you file your complaint with the Arizona Row already? If so, then we have to wait and let them do their investigation. She says, yep, I did. You did not respond. And then she says, yes, and I do not think the inspection will go well considering the circumstances. I need the contract and your insurance information. Oh, well. He says, okay, the investigator will probably contact me in a few soon, I suppose. And then from there, we should be able to set resolution if willing. And she says, I need the contract and your insurance information. Question mark. They're going to ask you the same question. So just give it to me. She then says on the 7th, I would like to review it before I talk with them. And then she sends him the one text message that it looks like we already read. So, I mean, I don't think he has to give her that. Even though defendant's insurance company information were also unanswered, even though the defendant had advertised on Facebook that his business was insured. Okay. So this is from that post. We would love to give you an estimate, license, voted, insured. They did fantastic work for us. I can give you a quote. I build all fence and custom fence. Oh, they're so bad at that. Okay. Does it say insured? Oh, yes. License, voted, insured. Okay. Just because he gave it to you doesn't mean he wasn't. Oh my goodness, right? Low and her deadlines. You better do it. You better do it. Or I'm going to tell the world. Tell the world about this. Ask for Jake from State Farm. Oh yeah, this is that. I wanted to see Wallace. I think Dave Neal actually talked with Sean from Lone Cactus back in the early days of uncovering all this. Like he did an interview. Man, I got to go find all these interviews. Because I need to know some more. So she can pay the money she owes Clayton in 2 payments then, right? The irony is just chef's kiss. Chef's kiss. Jake's phone is going to voicemail. Excuse me, Jake, you're not answering. All right. Where were we here? The Register of Contractors was contacted and a complaint was filed on July 7th that was never responded to by the defendants. All right. Which I guess we can read that if we really wanted to. Well, we might. Plaintiff was informed by somebody, an investigator, that the rock would not be the best route to go in order to get reimbursement in this particular situation. Yeah, because that's not what they do, boo-boo. He explained that the rock can only get contractors to fix or complete work, not reimburse for poor work. The defendant had already been given ample opportunity to fix his work and did not do so, and intimidated the plaintiff by trespassing. Therefore, the plaintiff did not want the defendant to return. The defendant did not file a written response to the plaintiff's complaint. Okay, but like, so if Rock can provide you contractors who are going to finish this job, why don't you take them? Because I'm going to go with there probably wasn't actually much wrong. So I don't know. All right. Legal standard. That's just mumbo jumbo for why they should get it right away. Here we go. Argument. From the outset, defendant deliberately misrepresented his knowledge. Oh, wait, I can do that now. There we go. Let's do that one. Oh, that's not great for our side people. Oh, that's too big. That's too much. I'm so sorry, vertical people. It's too close to my face. All right. So from the outset, defendant deliberately misrepresented his knowledge and expertise in, in the specialized areas plaintiff required for the aforementioned job. Defendant did so to fraudulently induce plaintiffs into entering a contract with him. Apparently a contract that never was signed for months, but okay. The plaintiffs selected the defendant as their contractor because he falsely claimed expertise in remodeling high-end horse facilities and its specialized products associated with the equestrian industry. I didn't really see that from his Facebook post, though, but okay. None of these claims were truthful, as evidenced by the subpar work that was performed. Defendant was also aware these claims were untrue at the time he made them, with the clear intent to induce plaintiff to hire him. Plaintiff relied upon these claims when hiring him and was therefore injured due to defendant's fraudulent claims and misrepresentation. The defendant performed significantly less work than his original estimate of $7,320, which included stalls for 6 horses, a wash rack, a feed room, and other things. Yet the final amount paid just to him, not including materials independently purchased by the plaintiff, was $34,508. The fact, again, so she is saying, hey, it was only supposed to be like $7,000 and now it's $30,000. And I know I provided you all the receipts of how much everything cost. I know I thought it was going to cost $7,000, but obviously, like what? Ugh. Not that I ever saw on legal doc. Oh, okay. This is who is big into horsey stuff. She knew Laura's name and not in a good way. Ooh. Interesting. I just know that the horse community knew exactly who and what she was for years prior to all this. Interesting. It's a small community no matter where you're from. I feel her parents having a name didn't help with the fast BS spreading. No, probably not. Did she just have horses for personal use, or did she rent out to ride or use for the show or rent out stalls? Anyone know? Apparently they were reselling these horses. She's flipping horses that are worth lots of money, apparently. In case you didn't know, they win all the awards. I don't know how true that is, but that's what she does. She has a business, Quartet Farms, that apparently she knows nothing about when she goes to the bankruptcy hearing recently. And that's what they do. She lost hundreds of thousands of dollars because of this. So the plaintiff earns side income, through buying and selling an investment horse or 2 at a time. Look at this, just in time, Ange. During construction, there were no facilities available to house or train horses at the residence. Thus, no opportunity to maintain the fitness of the horses, nor to accumulate a new horse to sell. Defendant left the project dangerous to animals. The plaintiff sold 3 investment horses in early part of 2021 for more than $150,000 before the defendant. I thought they said they didn't sell any during that, and that's why they were asking for so much money. Okay. Horse shows are 5% riding and 95% sitting around and gossiping. Yeah, I feel like they're just a big circle jerk, really. But given that the goal of the company is to sell 1 horse per month, the potential loss of income is about $40,000 per month, or $250,000 during the time that the defendant was supposedly completing work. The plaintiffs have yet to conduct any business in Arizona due to the facilities not being adequate, and the scope of repairs still need to be made. So you're saying we haven't been able to do that this whole year, even though The Rock would have, given us contractors to do this. And did you keep these horses in this shitty place, or like what was going on here at this point? When she filed this, when did she file this? Hold on, let me scroll up. 1/6/2022 is when she files this. January 6, 2022. This went down supposedly in beginning of December 2020. And she's saying everything is still super fucked up. And it's all his fault. Hold on, let me go back to my original page. This is why I didn't want to do that yet, but whatever. Because we're almost done with this part. I don't remember where I was. Okay, here we go. To date, plaintiff has tens of thousands of dollars in repairs to make due to defendant's negligent construction. Repairs will take several more months, if not a year or more. What? Resulting in further missed opportunities to earn income with an investment horse, as well as potential injuries to the animals. How did this all of a sudden take more time and more money? Okay. While plaintiff typically travels to horse shows more than 30 weeks per year to increase the value of a horse, she has been unable to leave the property overnight whatsoever since she became involved with the defendant, since there have been several instances where horses have become loose or injured as a result of the defendant's fault work. Also, probably because weren't you like suing Greg at this time too? I'm pretty sure you're busy. The plaintiff continues to make repairs as needed. The out-of-pocket expenses to attempt to mend his work have been astronomical. The negligence shown by defendant and his crew have led to several physical injuries to the plaintiff's horses, including an episode of lamatitis, lameness, injuries to the neck and legs of several horses, and severe cases of thrush to 5 horses caused by water damage from defendant's incorrect leveling and construction of the barn. Wow. No one in the horse business travels 30 weeks per year unless you're a horse hauler, right? There's no way she's spending that many weeks traveling. With what money if she's not able to sell horses? Right? Because I can't imagine traveling and you're bringing horses with you. I mean, that really does have to be expensive, right? Finding a place to store the horses. You can't just, take horses to a hotel, I'm pretty sure. Defendant had several opportunities to fix his poor work himself and chose not to. Defendant's blatant indifference for the harm he caused was egregious. Ma'am, I think you're egregious at this point. If you're still if this is so bad and so dangerous, like you explained it is, then you're egregious for still keeping your animals there. Defendant laughed when our horses escaped from his poorly constructed stalls, stating it was like they were playing musical chairs. Defendant showed a callous disregard for the health and welfare of the animals. Oh, she is totally lying. That's not what causes thrush. Is it thrush like stuff babies get from the bottle of like? Is there a different kind of horse thrush, or is this like the same? I didn't even know animals could get that. But she is totally lying. But he better not lie. No. The damages incurred by plaintiff are cost of materials and labor needed to fix defendant's poor workmanship, as well as supplemental expenses paid by the defendant for vet bills and a loss of income from any potential sale since the plaintiff's involvement with the defendant. Rights. Defendant violated Arizona's consumer fraud statute, which states in pertinent part, the act, use, or employment of any person of any deception, deceptive or unfair practice, unfair act or practice, fraud, false pretense, false promise, misrepresentation, or concealment, suppression, blah, 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 is responsible. The materials purchased by defendant were subpar and defective and warranted by the defendant and the law. The construction did not hold up against inclement weather, and negligent installation of footings and stable mats caused plaintiff's horses to slip and be injured, resulted in veterinarian bills. Okay, well, you didn't include, it's a yeast infection. Thrush, not just Laura. Laura's a yeast infection on all of us. You just can't get rid of it sometimes. Caused by unhygienic stall conditions, usually, not just water. Well, I'm not surprised. Then she goes on to talk again about Tiffany, who contracted Oh, wait. The negligent construction failed to properly finish an area for the horses to ride be shown, and negligent construction caused one horse, Tiffany, to contract laminitis, several show horses to have serious cuts and abrasions from sharp fencing, and all other horses to lose their health and fitness, amounting to animal cruelty perpetuated by the defendants. Okay, she has constantly been like, you guys have done so many illegal crimes, and yet there are no legal, filings of crimes that they did. So, just saying. She also says she suffered emotional damage from all the aforementioned events caused by the defendant. Defendant, knowing the serious health issues, here we go again, the plaintiff's family was facing, including Parkinson's disease, cancer, and heart surgery, claimed he would complete work quickly so as not to add more stress in their lives. Wait a second. Is this you also doing what you accused him of doing? Is trying to garner sympathy? That's right. I forgot. Her whole motto is rules for thee, not for me. I forgot. Yes, I want to thank everyone for all the extra info too. It's so helpful. Oh my gosh. Oh, what a crazy world this is. He delayed work, fabricated 50 plus stories for the delays, and repeatedly said he would show up to work when he did not. This meant that the plaintiff's schedule was determined by the defendant. In addition, the stress of needing to find stabling for plaintiff's horses was innumerable. Furthermore, on June 19th at 6:50, oh, here he goes. He's knocking on the door. We're not going to reread that. It's the same thing. That was in her other one. Blah, 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 blah. So they're asking the prayer for relief again to be compensatory damages in the amount of $150,000 and any interest, costs, and expenses incurred herein, including but not limited to reasonable attorney fees, court costs, and any additional relief as the court may deem just and proper. We know damn well she would ask for more money. So there is that. I'm going to, because I have not looked through the other part 2 and 3. That's just a bunch of exhibits that go along with that. But I included all the ones that she had mentioned. There's a whole bunch more. So I'm going to go through those tonight and see if there's any good stuff for us tomorrow. We are still on Lone Cactus, but we will wrap up Lone Cactus talk tomorrow, because I went a little bit over today, but I had to. I just had to. I had no more. So tomorrow I'll go through, see if there's anything else we need to pull from those two. Then we will have the defendant's response to plaintiff's motion for summary. And then we finally get to hear our first court hearings. That's right. They're not very long. One's 14 minutes, the other's 7 minutes. So they're not too terribly long, but I am very excited to finally get actually into court with one of these things here. That's where I learned it. Want to really thank you all. Yeah, we did that. To my knowledge, emotional distress is not a thing in contract disputes. I mean, everything causes her distress. It's so funny how she blames everyone for causing her distress. Everybody. But it's like, well, according to you, you've always had it. You're just constantly distressed. How can you keep being like that? Oh, I'm also going to look into the other horse lawsuit y'all told me about earlier tonight. We might cover that tomorrow too. I don't know. We'll see. So we'll definitely be doing all of that. Just went looking on Dave Neal's channel for the first time. I heard about Sean from Lone Cactus and Laura. It was on February 12th, 2004, titled Bachelor Clayton's Accuser Had Run In with Contractor. Okay, so he's on that. Ooh, all right. Sean is never on air, though. Okay. Well, I will definitely. The horse disinformation drives me nuts. Yeah, I mean, I think that's what she's hoping and banking on, right? If you don't know nothing about horses, you're like, how horrific. But, I mean, honestly, I do feel, remember Arizona, well, California, they're in Arizona now. I was going to say California, covers the pie. They do the pie math. I don't know if Arizona does, because I'd be like, you're responsible for putting your animals in the shitty containment when numerous people allegedly have said that it was shitty work. So why you kept doing that then? That's on you. We're all going to sue her for her bullshit. Talk about emotional distress. Oh my goodness. So that's where we're leaving off today. Tonight, True Crime and Wine Time, we're recording, Terry and I. 8 p.m. Eastern, we'll be covering the Cassie Jo Stoddard case, also known as the Scream Murders. One of many, actually, called that, because the people that do that are so original. That'll be tonight at 8 p.m. Eastern. I'm very excited about that one. I didn't know much about it at all, so that was interesting to learn. And then we will be back tomorrow here, 11 a.m. to wrap up Lone Cactus lawsuit and whatever other rabbit holes I find myself in regarding this, and wrap that all up tomorrow. As always, definitely leave more comments if you're part of the replay crew or you thought of something after I'm done. Feel free to leave it in the comments. I think you guys can link things into the comments too. So if you find any links you want me to go look at, I think you can do that. Maybe not. Or just let me know. And I will look into all of that for sure. If she doesn't get jail time, there should be a protest. Honestly, I'll fly to Maricopa County too. I don't even like flying, but I mean, it's unbelievable what she's done to people. And, you have the 3 public guys that she's done this to: Mike, Greg, Clayton, with all of her false BS. Uber, she got to have a settlement when she didn't have to prove shit. All right. Spoilers and how this one goes, but there's a settlement reached here, right? So she's feeling confident as fuck, because as this is going on, by the way, for timeline's sake, the Lone Cactus situation also happens when she starts the Greg Gillespie situation. They're actually going on at the same time, pretty much in 2021. So she's so busy and says, well, I can't travel, and it's all this guy's fault that I can't travel with my horses for 30 weeks. All the while, she's practicing pro se against Greg and going to town with these filings, which I cannot wait to get into next week. So it's just really funny how much she's blaming Sean and all of this, when really she's wrapped herself up in this whole thing with Greg, all this bullshit with Greg that she has to spend all her time figuring out how all that works. So it seemed like this guy just wanted, as with everybody, they just want to be done and rid of her. And that's done horrible things to her ego. So, it'll be 3 years by the time she's finished court. She needs to get at least 5. Because each of the perjury was 1 to 15 years. I don't remember how much the evidence tampering was. I feel like there's still more charges they could bring, but what do I know? Let's see. You should redact your email address from the recording in case Lo doesn't watch this until later. You don't want her to have it. That's true. But guess what I got? Free time. No, I'm just kidding. I don't. Then you told the MA what you were doing, and she knew about LO too. Oh, I love that. Oh, wait. Here we go. Sorry. I was like, wait a second. I'm missing part of this conversation. I got called out for high blood pressure at the doc on Tuesday after listening to the bankruptcy hearing over again, and told them that I was doing it. She knew LO too. Yes, it seems like a lot of people know about this, but more people need to know about this. And that's why I hope she doesn't take the plea deal, so we get a trial. It would be glorious. So, all right, friends. Well, that's all I got for you today. Again, please, if you haven't yet, subscribe to our channel, hit the notification bell so you don't miss when we go live with Laura stuff or drop an episode. I almost thought about going live yesterday for the bankruptcy hearing, but I was like, no, Llama, you're supposed to have days off, which I don't ever have, but still. Otherwise, I will be back tomorrow, 11 a.m. We also are going to have a new merch drop, by the way, Sunday, March 1st. There's some pretty cute stuff. In case you guys need to up your merch stuff, you can find all of our merch at tcwtmedia.com. We have lots of cute stuff over there. Anyway, damn, Dave. Damn. Oh my gosh, I know, right? All right. Well, thank you guys so very much. Until next time, my friends and couch potatoes, go forth and be amazing. All right. Bye, friends.